everyone. Welcome to Understanding Copyright and Building a Copyright-Centered Workflow. I'm Kristen Nenna. I'm the ASPP president of the West Chapter in Los Angeles. So thank you for coming out today. I'm really excited to have our speaker come up today and talk about copyright and everything going on in the digital world. I think that most people, like yourselves, you come from the loop generation where you handle negatives, duplicates, and slides and all that. And so the digital realm is so new to all of us, and I think everyone has a lot of questions revolving around how you protect your content online and promoting your content as well. So right now I'd like to introduce Chris Reed. He's a photographer and copyright lawyer and former senior policy advisor to the U.S. Copyright Office. So once I'd like to welcome Chris Reed.
Thank you very much, Chris. Thank you to ASPP for having me and hosting the event. ASPP was sort of the organization that started it all for me. I was working at the Copyright Office, and they wanted ASPP had asked for my boss at the time, the director of the office, to do some speaking for them in Chicago. And she wasn't able to make it, so she sent me. And then I ended up doing, I was joking with Chris earlier, that if I do Seattle next month or something, I will have done all of the ASPP chapters. So I can check that off on the bucket list, but it was always great to speak with ASPP folks. I particularly like ASPP actually because it represents the full sort of image ecosystem. It's not just photographers, it's not just licensors, it's the entire community. So I like that a lot. So the talk that you're going to hear today is, first of all, it's designed to be somewhat interactive, so feel free to ask questions if you're confused about anything as I go along. And we'll also have some time at the end for general questions. But this was based on a combination of working with organizations like ASPP on speaking to photographers, and I noticed that a lot of the questions I was getting were all very similar. All had to do with registration and how you deal with the Copyright Office registration system, which is frankly very good for photographers. We'll talk about. It was a mix of that and recognizing that there's this strong interest among photographers in talking about workflows and how things fit into the workflow and digital asset management and all that sort of thing. So I thought, well, I can put these two things together and come up with a process by which you can build copyright concepts into a lot of the type of work that photographers are already doing. And so that resulted in a book that I published last October through Each Bit Press, and that evolved into this talk today. So I'd just like to quickly go through where I'm going to head today. I'm going to start off with the basics of copyright. For many of you, this may be a repeat. It's the kind of thing that comes up a lot at photography-related events, but it's important, I think, that we're all on the same page as far as what copyright is, what it protects, what it doesn't protect, and that sort of thing. I'll then move into what I would call the copyright workflow, which are these three phases here: planning and setup, registration and records management, and monitoring and enforcement. I sort of made a strategic decision to not spend a ton of time getting into the nuts and bolts of the registration practice. We're going to talk about broad concepts and sort of the general framework of registration and how to prepare things for registration. But what I didn't think would be productive is to go through sort of screen by screen as far as how you do that, because it's, I see some laughter, or hear some people laughing. It's laborious, it's time consuming. The Copyright Office system is often not up on the weekend, so it makes it risky to do it at a scheduled talk. And it's frankly, there are a lot of other resources out there that you can use to rely on that. So what I'm trying to do is give you the big picture about registration and help you figure out how that fits into your business and your practice of photography. So we'll do that in this section. I'll talk briefly about sort of the future of copyright law, because a theme that will come up throughout the talk is that copyright doesn't really do a great job for photographers now. People's images are getting ripped off left and right. The registration systems I mentioned doesn't really work. And people get tired of hearing it, but they're working on it. Copyright Office is working on it. Congress is actually working on it. And so hopefully we will see some results in the next 5 to 10 years, which, believe it or not, in Washington speak is fast. So we'll talk about that a little bit. And then, as I said, I'm going to save some room for questions coming in. So a few ground rules before we get started. Nothing I say should be construed as legal advice. The standard lawyer disclaimer. I apologize. Everybody here is special and unique, and that means that your legal issues are special and unique as well. And so when I'm providing sort of general framework, guidance, and educational information about the law, and this sort of relates to these other 2 points here, photography I have found is very religious in that people find a way of doing things and then stick to it, and everyone else is wrong. And what I'm going to describe to you, aside from what copyright law says, is not prescriptive. It's what I do, it's the process that I go through when I register my work and how I built it into my workflow. It may not work for you, and there may be bits and pieces of it you want to take and bits and pieces of it you want to reject, and that's totally fine. But I just want to make sure that's clear that this is not designed to be, don't come away from this thinking you were doing it wrong, because there are lots of different ways of getting to the same result. This is one way that I think is sound, and feel free to take it. So with that caveat, those caveats, I'd like to start off with this general question of what is copyright? And I think this is the part of the presentation where I think we need to all get on the same page. So I'm going to walk through some simple questions, and we're going to figure out from that what copyright is all about. So a very technical description of what copyright protects. This is more or less right out of the copyright law. It's original works of authorship that are fixed in a tangible medium of expression. You'll note that original and fixed are both in italics. These are what the lawyers call prerequisites to protection. It has to be original in the sense that it isn't copied. So that doesn't mean that it's never been done before or it's truly original. An example of that is like I have a photograph in my collection of Old Faithful. I was pretty impressed that I got that particular shot, but it looks like pretty much every other signature shot of Old Faithful you've ever seen. That image is still, I still want to copyright that image because it's original to me. I created it by myself. I didn't copy it. So that's all originality means in copyright context. And fixed means that it's in some tangible form. So an example of something that isn't, but still may be original creativity is like a snowman or a sandcastle, right? It doesn't exist long enough for copyright protection to attach. A photograph of those things may well do that, or may well have a copyright. Another example of this are things like sporting events. Anyone who's watched a sporting event has seen the very scary copyright notice that the various leagues put on the telecasts. The game itself is just a game that is happening. There's no protection in that at all. The recording of it is protected. So you can protect things like that by simultaneously fixing them in a tangible medium of expression. That is that. What is in a copyright? It's kind of a not well-phrased question, but what I'm getting at here is that copyright, although we call it copyright as if it's a singularity, it really isn't. There's multiple rights embedded in that, and these are the big ones. The right to reproduce, which is sort of the namesake, right? The right to copy the work. Distribution sort of relates to that. Once you have the work and can make copies of it, you then have the right to distribute them. Preparing derivatives, good examples of this are, I've written a book and then I want to convert it into a movie. The movie is a derivative of the original work, and this town is built on the creation of derivative works, right? We take literary properties, and the movie industry takes literary properties and makes them into movies all the time. We'll do that, and we'll take, and make, other products based on that. Those are all derivative works. And then finally, this one's big for photographers, the public display or performance of a work. Public display, big issue for photographers, as you imagine. This governs things like this in concert with distribution. It covers online distribution of images. So we post things online, those are the rights that you're exercising. Or when somebody else does it, the rights that they're infringing. So who owns the copyright when you create a copyrighted work? Generally speaking, it's the author. It's that simple. It's whoever had the creative vision and implemented that creative vision owns it. And I'm oversimplifying a little bit. It can get tricky when there's multiple people involved. It can get tricky when there's an employer involved. In cases where you're the employee of some entity or some person who has hired you to take pictures, those pictures are owned by the employer. Now, most photographers, how do we figure out if you're an employee? We use the same test that more or less the IRS uses to figure out for tax purposes if you're an employee. So it's things like, were you doing it on company time? Are you paid a salary versus paid by the job? Did they pay health insurance? Did they withhold taxes for you? Those sorts of things would suggest that you're an employee. If you're paid, you use your own equipment and you're hired to do the job and then you go away again, that suggests you're an independent contractor, and that would mean that you own the rights to your images, and that somebody else, you have to license it to the client.
So it's not specifically you signed a work for hire?
Well, that's a different way. So work for hire gets really tricky because there's what you just said is not quite what the law says. So people will often sign these work for hire agreements unless the work you're creating falls into some very specific categories in the law. It isn't a work for hire. It just cannot be a work for hire. A work for hire is, under the law, done in an employee, a work that is created in an employer relationship, like I just described, or one that falls into these very specific categories and the parties agree to it. So it could be, depending on if you're working.
But just by virtue of working, fitting those categories that the IRS defines, that is work owned by the employer.
So those sorts of tests inform our view of whether That is, whether under copyright law or the ownership test. It's not an absolute. So that all flows out of the case, actually. So it's judicial. It's not in the statute. And the case says to figure out whether how we figure out ownership, we look to agency law, which is a form, it's common law. It was developed over the years, and it's different in every state. It's a mess. And then the IRS roughly uses that same guidance. So I was using the IRS as sort of a shorthand thing. It isn't really based on the IRS rules, but it's very similar. So that's.
I'm sorry to interrupt.
No, that's okay. Work for hire is one of those things that's completely misunderstood. I've seen some very sophisticated copyright lawyers mess that up because it isn't. It's clear in the statute, but there's this idea that work for hire means I did it for somebody who paid me, and that's not the end of the story. It's unfortunately not that simple.
What all you have to do is have an invoice the people.
Well, the question then becomes, well, the invoice for what? So the invoice for.
Event.
Well, right. So it gets complicated because I might pay you a day rate to shoot my event, but that doesn't necessarily include the copyright license to use those images later. So typically, most of the big photo trade associations will advise you, and I have mixed views on this depending on circumstances, but most of them will advise you to bill for those separately. So your day rate is for your labor and your creative input in the post-production and all that. And then the licensing fee is based on the usage of those images in particular contexts. So let's say I hired you to shoot today's event, and then I wanted to use those images on my website. You might charge me one rate, but then I end up using them on billboards. You would want to charge me something else, right? Because more people are seeing that. So that's why they encourage you to separate those out. So the invoice itself might be again, it informs our view. Like if we were in litigation over who owns the copyright, that's something that somebody would introduce as evidence based on what I know is going to prove. So it's it's informative, but it doesn't answer the question. Speaking of questions, so how long is the copyright last? Does anyone know?
Like 70 years, Pastor Dan?
Right. Life plus 70 for a standard work created by a single author. For works made for hire, again, works made for hire are complicated. It's 120 years after creation or 95 years after first publication. We'll see publication as a concept that comes up a lot. This is one of the reasons why it's still relevant today. A lot of people, particularly photographers, are really frustrated with the distinction between published and unpublished works. One of the reasons it's still relevant is because if it's a work for hire, your duration of copyright is pegged to it. So it's still a very important concept. Is copyright absolute? By which I mean, are those rights that you have, the ones I went through earlier, reproduction, distribution, all that, are they without any limitations? And the answer is no. There are, I'd say roughly half of the Copyright Act is comprised of very carefully crafted limitations and exceptions that place restrictions on the rights, the exclusive rights of the copyright owner. The reason for that is largely motivated by public policy. Congress has decided there are certain uses where, for various reasons, it might be market failure, it might just be a socially desirable purpose, we want to allow people to use copyrighted works either without compensating the copyright owner, in the case of fair use, which comes up a lot, or based on compensation that's set by the government. And those we call statutory licenses. There aren't any, slight overstatement, there really aren't any statutory licenses that apply to visual arts, so I wasn't going to spend much time on it. They are very prominent in music. So in certain circumstances, I can use a piece of music and I don't have to ask permission, but I have to pay the statutory rate back to the copyright owner for the use of that music. The entire radio industry is based on certain of those statutory licenses. And actually one of the big policy debates right now is that the rates online streaming companies pay are very different than the rates traditional radio stations pay. And increasingly those markets are starting to converge, and everybody's really upset that there's no parity in how much they're paying. So that's an example of statutory license. An example of just an outright limitation, as I mentioned, is fair use. We were talking earlier about fair use. I wasn't going to get into the details, but broadly speaking, the fair use test in copyright law lays out 4 factors that courts are supposed to consider. And then over about 100 years or so, courts have developed those factors. And so now to figure out whether something's a fair use or not, we have to look at how the courts have interpreted each of those factors, as well as the facts and circumstances of the case. So it's very hard to look at something and say, that's fair use, that isn't, that is, that isn't. In general terms, you have to be very specific and look at the type of use and what the type of the underlying work was and things like that. Increasingly, courts are finding fair use more often. And the reason for that is because a lot of the other limitations and exceptions in copyright law are very, very old. The version of copyright law we're using was passed in 1976. It was effective in 1978. That was long before the internet, and so a lot of the types of uses that people want to make of these works today just weren't comprehended by the Copyright Act or by Congress when they passed it. So to alleviate some of that pressure, courts are more quick to find fair use in cases when traditionally it wouldn't have been fair use, and it's putting a lot of tension on the system right now, particularly with visual artists. As I said, I don't want to get too much in the weeds on that, because we can talk for days about it, but I just wanted you to know that it's out there, because you'll hear it a lot. So, does anyone know the answer to this question? How do you get a copyright? We talked about it, your works, photographers are protecting a copyright. What do you do anything to get it?
Just create it.
So you have to create the work. We're going to talk a little bit about copyright registration. That does not require, you're not required to register your work to have the copyright. So this is not like a patent. Patents, you have to go to the government, and the government looks at your thing that you invented and says, yes, that is original and novel, and you get to have a patent for 20 years. Copyright is almost exactly the opposite. You just have the copyright upon the creation of the work, but registration can be useful for a variety of reasons. I'm guessing so the main one is that it gives you the ability to get into court. It is almost literally a ticket into court. I used to, right out of law school, work for a judge. We had a copyright case come in, the work wasn't registered. We stayed the case basically and said, go register the work. They registered the work, came back with a certificate, and we moved forward with the case. So the reason for that is the registration provides a public record of ownership. Now you've put the world on notice under penalties of perjury, which is the real reason you have to register to get in court. You've now stated certain facts about that work that are part of the public record upon which your lawsuit is based. The hook for registering quickly is that if you register within 3 months of publication, or it can be after that, but before a particular infringement occurs, you're eligible for statutory damages. And all that really means, that's a fancy way of saying you wouldn't need to prove how much you actually lost as a result of the infringement that you're suing on. And that's really important for visual artists because in a visual artist space, it can often be very difficult to prove that. First of all, it's not just unique to visual artists. It can be very hard without, even with access to the records of the defendant, it can be very hard to figure out exactly how much you lost as a result of not licensing that image. But more importantly, the reality today is that most typical uses of images are not, the usage fees are not very high, and certainly not high enough to justify spending a bunch of money on filing a lawsuit, right? So the cost to just get in the front door of the court is probably around $100,000 if you have a lawyer do it the proper way. So unless you're looking at an award of beyond that, plus attorney's fees, which is the other thing you can receive from the defendant, it's just not worth it. And we'll talk later about sort of the, you said earlier about the future of copyright law. It's not really working right now for visual artists. One of those issues is access to the judicial system, because it's just so expensive, and the value of any one infringement to a photographer is so low that it's just most photographers aren't able to effectively enforce their rights. So that's the carrot that the government, the copyright law offers us to encourage us to register our works. Can a copyright be bought and sold? We've talked about sort of the rights you get. It kind of feels like a property right, which suggests it can be bought and sold. And you're right. In the copyright context, we call it a transfer. We've already touched on this, though. In the intellectual property spaces, licensing works is far more common. So you can think of licensing as leasing or renting an apartment versus buying a house. The nice thing about copyright law is you can carve up your license almost infinitely. So you can do it by territory, you can do it by type of use. Increasingly, there's been a push in image licensing to go for all rights worldwide forever and any perpetuity, and to lower the price as you're increasing the rights. That's just a function of the market. It's not that licensing isn't working, it's just the market's pushing the licensing fees to places that are unfortunate for visual artists. This is important because you can also, I don't get into this much later, but I wanted to just mention it. In big transactions, you can, well, in any transaction, but you really only do it in big transactions, you can record your license agreement with the Copyright Office. And this is just like when you buy a house, you put a copy of the deed, the transfer, in the Registry of Deeds, so that anybody in the world can go to the Registry of Deeds and look up that you're the owner of that particular property. Puts the world on notice of the transfer. That is very common in industries that rely heavily on intellectual property. Again, Hollywood is a great example of that. I work for my day jobs at one of the studios, and we record all of our transfer agreements. If we option a screenplay from somebody, we record that with the Copyright Office. practice. When we produce a film and license it to somebody, we report that to the Copyright Office. When I was at the Copyright Office, I noticed that HBO, the television network, they register every single license they get from studios, which is, it's expensive to record documents, so I was surprised to see that, but they're registering thousands of documents a year. When they get the rights to a particular movie, they report it to the Copyright Office. And all it does is clarify the record so everybody knows that they have the rights to do it. You don't have to record the material terms of the license, you can do what's called a short form. The point of all this explanation is just to know that that's out there, so if you ever do, like, you're licensing your entire catalog to somebody, or you're licensing in an entire catalog from somebody, high volume transactions, it's useful to have that on the public record in case there's a dispute down the road. Typically, you wouldn't want to record, or it wouldn't be worth recording individual licensing agreements and things like that. It's just not worth the cost and expense. So, is there a question?
You just answered it.
Okay, great. Yeah, so I mentioned earlier, half jokingly, the registration system does not serve photographers particularly well. The recordation system does not serve anybody particularly well right now. It's entirely paper-based. The turnaround time for certificates of recordation, which is basically just a thing that says, yep, we've got it on file, here's the number, is something like 1.5 years. It's bad. And there's literally, like, I used to work there, and there are literally boxes of filings just on people's desks and stuff. Not that they've been neglected, it's just that there's so many of them that are backlogged. And we'll get into, I'll mention later, but the Copyright Office is really starved for funding right now, and every time they try to put their fees up, photographers, frankly, usually the most vocal, criticize it. And that's fair, because there's this public interest balance of keeping copyright registration reasonably priced so that we will do it. But at the same time, you need to fund the agency that's doing that work. And so it's a big conversation that's happening in Washington. So what is licensing? Very topic. So yeah, you can think of that as just, it's giving permission to use the work with certain restrictions, and you can slice and dice them however you like. So getting back to our original question, if we want to summarize what a copyright actually is, we can say it's a property right in works of authorship, it's a tangible medium of expression. You can buy, sell, and license that. This is an important clause subject to certain limitations and exceptions. You can't license to somebody and then exclude someone else's fair use rights, for example, or something like that. So you have to bear in mind that any kind of transaction you're engaging in, there are still these limitations and exceptions behind the scenes there, where somebody may want to engage in certain use and they can do it even though they don't have a license to do that.
Without spending too much time, is there a way to drill down into the term fixed? Is it defined? Because you said you used the snowman as an example, but there must be some legal.
The standard, yeah, so the phrase we usually use is that it's fixed for more than a transitory period of duration. I'm sure there's some cases on it. I've never looked at them. Quite honestly, or not recently looked at them. In our world, that doesn't come up a whole lot. It's very rare that a copyright case rises and falls on whether the work is fixed or not. It might. I mean, I could conceive of some scenarios, but it would be very law school.
The original part is the most important.
Yeah, that's the big part. Yeah.
I feel like botanical gardens and landscape design.
Well, that's
copyright.
yes. There was a case actually recently where they held the garden design was not protectable. Although I'm not sure. Was that on? Did that case rise and fall on fixation though? I don't remember the court's reasoning in that case. I mean that's a good example of something like a change, right? So it's not necessarily the photos of it.
Well, negatives and prints change. So.
Yeah, I mean that's right. So the DVDs on which my images are stored are rotting and they're no longer fixed. But it was long enough that you could do all of the things that you can do under a copyright, and that's, if I had to guess, I think that's how a court would probably consider it. Was it fixed long enough that I could prepare derivative work from it? Was it fixed long enough that I could reproduce it and distribute it and make copies of it? If it is, then that's probably sufficiently fixed. But like I said, I don't. I mean, that's a couple of pages in the textbooks usually, so it's not. That's not to say it's not. I mean, it comes up in digital, I guess, because there's this question of, well, when you just have a bunch of bits and you arrange them on your memory card. At what point does that become sufficiently fixed for purposes of copyright? So maybe you can bring a test case on that.
You fund it.
Yes. How can I protect our copyright? All right, this is a shameless plug into our next section. So you can. My whole pitch is that you should build these ideas into your everyday practices And so it becomes sort of second nature. And I don't know, how many of you are photographers in the room right now? Shouldn't ask that, right? Okay, so most of you. And how many of you have registered your works? How many of you register your works with regular? Exactly. That's almost always the answer. It's the same question. And so my whole pitch is there are compelling reasons why you want to register. We've talked about that. The best way to do that is to build it into your practices so it becomes routine. And if you do that and you spend the time to set that up, it actually is pretty easy and straightforward, notwithstanding all the problems with the copyright office and the process and all that. So I'm just going to put that up to freak you out a little bit. This is kind of the workflow that I've come up with, divided into 3 sections. We'll get into this in a minute. You don't need to memorize this. Don't try to write it down. We're going to drill down into this. But this is kind of where we're headed. And I was thinking of it from literally a complete sort of life cycle of an image perspective, where I'm going to capture an image here, and then I'm going to store and share that image down here, and then there's all this copyright stuff that happens in the middle. And so we're going to work through that now, and as I pointed out, there's 3 phases. There's what I call the planning and setup phase, the registration and records management phase, and the sharing and monitoring phase. And we'll start obviously with the planning and setup, which in turn breaks down into these 3 sections. You'll notice on number 2 that I mentioned Lightroom. And you will remember earlier I said that nothing here is prescriptive. So don't assume that you have to use Lightroom to do this. I use Lightroom, and I think, frankly, the data suggests that most people are using Lightroom now, particularly after Apple finally pulled the plug on Aperture. But what I'm going to show you a couple screenshots there from Lightroom. My understanding is most digital asset management systems can do similar things. And so, again, this is all sort of an example of how you might want to set things up, but not necessarily the way you want to do it for your system. So I'm not suggesting that you have to pull out everything you've built over the years and you start using Lightroom just to do this. That's definitely not what I'm doing. So the first thing that I do, and I encourage everybody else to do, is to check your camera and make sure that you have the copyright information embedded in the image as soon as you created it. You were shooting with the 7D back there. These are screenshots from the 7D firmware. It allows you to put in your copyright information right into the firmware so that when you shoot an image, that's already burned into the file. One of the big challenges in this space is that that is not persistent, which means that I can then take your file and change it. And that creates what we call, well, it's fraud, but it also creates an orphan. It could potentially create an orphan work, which I'll talk about a little later. That's been a really hot issue in the photography community. But if this information weren't in the image file and it ends up on the internet and I get the image, I have no idea. There's no way of figuring out who owns that, for the most part. I mean, we'll talk about image searching and reverse image searching a little bit later. But bottom line is, you want to include this information as early as possible in the life cycle of the image. So check your camera settings. I know all the Canons can do it. I'm pretty sure all the Nikons can do it. I don't know about all the mirrorless stuff that's out there right now, but I strongly suspect that they can do it as well. Does anyone know if anyone shoot like 4/3 or mirrorless systems? No? Okay. Yeah.
Quick question.
Sure.
How important in the copyright is including the date? Is this something you need to update annually?
So, no. Well, yeah, so you're referring to like the copyright notice or it's important for some things, but not. So the reason I didn't put the date in here is that the date is separately written in metadata, right? So when you shoot an image, assuming that it's not on here, but somewhere else, there's somewhere where you set the date and time, right? And so your date's already in the metadata. What you might be thinking of is copyright notice, where the traditional circle C and then copyright and then the date. That actually should be the date of publication. If you read in the Copyright Act, the date you put on the notice is the publication date, which is why it's not super important that it be attached to this copyright thing here. And then the other reason is what I was alluding to a minute ago, is that it's all in there, it just may not be in the same place. So, and some of that's just because it's a function of what Canon set up the systems. Yeah.
I recently noticed, and probably the other people knew this long before I figured it out, that Tumblr, a lot of these programs that compress, strip out all metadata. Which I was shocked.
Yeah, it's ridiculous.
Yeah.
And they assert their argument, and you may know more than I do, working on advocacy stuff, but their argument usually, I think Facebook's argument is something that was that it reduces the file size, which is just completely ridiculous, because this is, I mean, it's not compared to the size of the
Their terms of use also allows them to sell your image.
Well, right.
You know?
We'll talk about terms of use.
Yeah.
And actually, I have a slide on metadata. There's a website, I think it's metadata.com. They do routine tests on a lot of these services, and they basically try to shame them into fixing their systems. Generally speaking, you find that the free services, the social media services like Facebook, they are the worst. And then like Flickr, I think, preserves the metadata. All the big commercial like Photo Shelter and Smoke Mug, it's the services you pay for, maintain it, right? Because they're catering to a market where that's important. Facebook, the average user that's uploading their selfies on their phone, they don't care about any of that. So yeah, I'm pretty sure Flickr maintains it. 500px didn't and now does, I think. They put up like a grid. I'll show you a screenshot of it later. It shows you that. Unfortunately, when I was talking about metadata not being persistent, that's one of the problems, is that there is, as I'm aware, no way of locking the metadata in, and I don't really know why the camera manufacturers haven't done it. I know ASPP has been very active, GMOS has been very active in trying to get something done in that realm, but I don't think it's ever happened. Someone told me Canon for a while had some technique to do that, but I don't know what happened.
That feeds right into orphan works, and that's what.
What's that?
That feeds right into orphan works.
Yeah, exactly. No, it's a key issue. And so the next piece of the workflow is to set up presets in your digital asset management software, which is what I've done here, so that in addition to the information that's already on the image in the card, or on the card, as soon as I ingest it into Lightroom, I apply this information to every single image. And you'll notice that this is not overwriting, it's overwriting the fields that I already put in the camera, and the reason why I'm sort of redundant on that is if I lose the card, or if the raw files end up somewhere without having been ingested into Lightroom first, that information is there. It's just a general rule, embed the information as early as possible in the process. So,
So what if you move?
you can do so. Lightroom, and I would imagine most other systems, will allow you to update this as batches, which is exactly what happened to me. I moved here from Washington last year and did exactly that. A trickier question is that all my registrations at the Copyright Office, which I'll show you some screenshots of in a minute, all have my DC address on them. And the Copyright Office does not yet have an easy way to update address information. So we've seen a development of third-party databases that are setting up that want to interact with the Copyright Office and then merge. So I could go to this third-party database and update my information, and then it pulls in my information from the Copyright Office. So let's say you find one of my images, you can use this third-party database to figure out where I actually am now. The thing that makes that tricky, there's a lot of people with a lot of good intentions that want to do that, but the Copyright Office has no way of exporting information in batches. There's no API, basically. You can't have the Copyright Office system talk to private systems yet. Again, working on it, it's on the list. Look into it later when they have the money to do it. So the other advantage, I suspect most of you know this, but if you flag this copyright status thing, this is part of the IPTC standard. If this says copyrighted, then in most professional programs, by which I mean Photoshop, you will see this C at the bottom and at the top of the file name. And that, this a theme that will come up later when we're talking about sharing images is that nothing really is absolute. So we can do all this work, but the bottom line is if somebody wants to rip off your stuff and use it, they can do that, and they will do that, unfortunately. But these are just little things you can do to make it a slightly bigger hurdle. Somebody may see that in a if they're professional and realize that they need to make sure the license is clear before they use the image. It's just another, this is all about sort of incremental steps we can take to try to maximize the protection. And none of these techniques in and of themselves will is foolproof. So this is the last part of the first phase, and that is figuring out your copyright registration strategy. And there's sort of three ways you can do this. If you're a low volume shooter, so let's say you're a high-end fine art photographer and you only put out a few pieces a year, the single image approach might work for you. For most of us though, we're shooting a lot more than that. And so you kind of have a decision to make about whether you want to register on a shoot-by-shoot approach. So this may work for, say, a photographer or a travel photographer who can break it down by trip or by job. And then there's the periodic approach at the end there, and that is based on time. So you might register all your images shot in first quarter of 2015, for example. And I think actually, yeah. So this next slide shows examples of that. Single image is very self-explanatory. It's you register one image in the name of that image, and that's that. Shoot by shoot might be something like, one of my registrations is called Chris Reed Photography Istanbul 2012, which, as you might guess, was a trip to Istanbul in 2012. All those images registered at once. And then the periodic approach is something like that. It would be Chris Reed Photography first quarter 2015. Little in the weeds point, if you go with the periodic approach, can anybody, yeah, we talked about this. Can anybody tell me what a really good idea for a length of time would be in between registrations? So that would certainly be relevant. There's another more fundamental point of thinking.
By year?
That's a good organizational principle. There's a legal reason why you might, yeah.
What 90 days you were talking about earlier?
What's that?
In 90 days from
If you do it every 3 months, if you're registering as published works and you do it every 3 months, you're never more than 90 days. You're never more than 3 months away from the date of publication. So you'll always be within that retroactive period for statutory damages and attorneys.
But it's the confusion of published versus unpublished.
Yeah, we're going to talk about that.
Yeah.
This is on a slide later, but I'll skip the bottom line. You should try to register your work as soon as it is out of the camera. So call it the card dump registration. As soon as you finish shooting, you register your works with the Copyright Office. And I register everything. The blurry ones, if you're doing portraits, I do the people with the blank, everything. Just register the entire shoot because you never know where those images are going to end up or what you might want to do with them later. I tend to use this because I don't actually shoot that much because it's not my full-time job. I've done periodic. I've done all 3 of these, but that's my common one. And as soon as I'm done with the shoot, put it into the Lightroom. I have my filing convention and all that, and then I spit out the deposit and register it with the Copyright Office. And I'll walk through how all that works at some. But like I said earlier, I'm not going to go through like the screen-by-screen examples, but I'm going to kind of show you the process using some key screenshots. So this is often an issue that comes up. Those last 2 options, the shoot-by-shoot and the periodic example, often come up as potential challenges because it requires that you register multiple images on one registration form. And a number of photography advocacy organizations, and a number of prominent lawyers have suggested that is actually not a good idea because you run the risk of having the collection considered, the batch of images considered as a batch of images. So when it comes time to calculate damages, they consider the group or the collection as one work. And then let's say it was 1 of 1,000, they take whatever they think the work was worth and divide it by 1,000, and then you end up with like pennies for the image or something like that. My view is a little bit different. I actually don't see that as a huge problem, and I haven't seen a lot of case law that suggests it is a problem. And last year, we got a decision out of the 9th Circuit, which was very useful. Quick background, which I should have mentioned before we get started. The group registration and unpublished collection registration, which are the tools we'll use, and I'll get into those in a minute, are creatures of the Copyright Office. They created them as an administrative convenience, both for photographers as well as for themselves, because they didn't want to be getting, like if you're shooting 10,000 images, they don't want 10,000 registration forms. They love the money from the 10,000 registrations, but as an administrative matter, it's a huge pain in the butt to have to register all that, to work through all that. So the idea of creating these batch registration options is very useful for the Copyright Office. And it was the subject of some litigation recently when stock agents, Houghton Mifflin, overshot their license. They were doing this routinely. They would license, a print run of 5,000, knowing full well they were going to run 10,000 or something like that. They got caught, sued, and one of the issues they brought up was that the registrations were invalid. They said, well, whatever, it doesn't matter what we did because your registration is completely invalid. And the court came back with some very nice language that said, no, we think the Copyright Office gets to make those kinds of decisions. That's basically what this says. So my view has always been, but it was nice to have it confirmed by this case, is that those sorts of registration options that the Copyright Office has created have specific terms in them that say this registration shall be construed to extend to each piece of the collection or each piece of the group. And this basically says they're allowed to do that. Now, the naysayers will say, well, this is one case from one court, and that's right. It's a pretty influential court. The 9th Circuit is very influential in copyright cases. Sometimes it can be a bad thing. But it's sufficient for me to not worry about it so much. Although full disclosure, I've never had any images in litigation. So it could be that if I get sued and somebody challenges my registration, I'll have a very different perspective. But for now, I'm comfortable with this language and the procedure that the Copyright Office has set up. There's some other technical legal reasons why I'm not comfortable that I don't want to waste your time with, but by and large, you just understand that I think it's safe to do that. And I'll get into more details now. So they've created two frameworks through which to register groups of images. And I hesitate to use the word groups because that's actually a term of art. You'll notice that the term group only applies in the case of published images. If they're unpublished images, it's called a collection. And there's some technical legal reasons why they've done that, and that I won't bore you with, but for today's purposes, what you need to understand is that if you're going to register groups of images or collections of images, you have to understand this distinction between published and unpublished. And somebody mentioned that earlier, it's being a real pain in the butt. We'll talk about it now. Here's why it's a pain in the butt. This is the first part of the statute that deals with the Copyright Act, that deals with whether something's published or unpublished. So take a minute and read that. And then I'm going to ask you some questions. So based solely on that, if I post an image to Facebook, published or unpublished?
Published.
Published? Anyone think it's unpublished? Yeah.
If you included a copyright or something on there, it wouldn't have been, in other words, if you ask somebody to download or ask them to do something with it, doesn't that make it published?
You're skipping a few slides. That's basically, that's basically it, is whether you ask somebody, whether you've enabled certain conduct. But the point of all this is that this is the next part of the definition of publication. And so it almost sort of undoes some of what it does up here. That if I do all of this for the purpose of transfer of ownership, rental, lease, lending, but then if I'm merely performing it or displaying it, it's not a publication, which calls into question. So it's sort of like this is saying, well, if I put it on Facebook, it's not published because it's just a public display. So that's why it gets tricky. People aren't ever sure whether it's published or unpublished, and they spend a lot of time worrying about this. And here's kind of where the Copyright Office last year released a new version of it, what they call a Compendium of Copyright Office Practices, which is a 1,200-page, very dense document that really just documents the Copyright Office's practices on certain things under the Copyright Act. It doesn't change the law, it doesn't change the regs that interpret the law. It just documents how the Copyright Office goes about its business. And it's kind of, this is not their language, it's me paraphrasing, but it kind of sets up this dichotomy. And you'll notice this typical lawyer thing where we're just saying likely unpublished, likely published. It's kind of tough to make absolute statements. But generally speaking, if you're putting it in a context where you're trying to get people to distribute it or trying to get people to buy it, it's probably published. Whereas if it's just in a forum where you've posted it and you kind of made it clear, and this was your point a minute ago, that you shouldn't be making copies of it or distributing it further, it's probably unpublished. Now, the additional complication that we'll talk about a little later with social media is that somebody mentioned terms of use earlier. Terms of use expressly allow the social media, the site provider to distribute that image. And so a strong argument could be made that that is in fact published. And so it is opposed to unpublished because it's merely a public display. So that's where it gets tricky. And again, the reason that gives you 1 second. That's why I say register them as soon as they come off the camera, before they've gone anywhere, because there can be no question at that point. There's probably an exaggeration to say no question, but it would be very hard to assert that images that have only seen your card and your hard drive have been published. So that way, that's all I did. I write off the card, unpublished, and register that way. So we had a question.
Yes. It sounds like you use the next picture. And your picture's on the wall.
Yep.
And then it has a price.
Yep.
For sale.
Yep.
It becomes published.
I would consider that one. That's right. Lots of questions.
And to that question, I talked to someone at the Copyright Office who told me it was not
It was
published.
not published, yes. I don't doubt that they would have told you. And I don't doubt that if you call back on Monday, I used to supervise the department that answers the phones. We call them. So right there in the room.
I have seen instances, and I don't know if this makes any sense or helps or doesn't help, of photographers when they posted, they want to put some of their things on social media, like say, for example, Facebook.
Yep.
And they'll put like in the in the caption or in their mention, you know, copyright so-and-so, all rights reserved.
Yep.
Even though it's a Facebook posting.
Sure.
Does that do anything or absolutely not?
It's helpful, but again, you have the problem with the fact that you have effectively licensed that, and notwithstanding your copyright notice, you've effectively licensed that image to Facebook or whoever to distribute it to its users, and
Okay,
then perhaps other people. because-
Facebook can do it, but can someone else take it and use it?
Well, no, but whether it will stop them from doing it is an entirely different question. But the fact that Facebook has that license, I think is sufficient to get you in the published.
I see.
So for that purpose, I would consider it.
Instagram's a big one.
And Instagram's got really egregious.
Well, their own.
Yeah, well, right. Well, didn't they, and you probably know better than I, they had really aggressive, they changed the terms of service, they were really aggressive, and everyone flipped out. And then didn't they revert back?
No,
They did.
that's what everyone believes,
Oh,
but if
okay.
you read it, it's in there.
Oh,
It's
so they
still in
pulled
there.
it. Okay.
And our attorney still has a problem with it.
Yeah,
'Cause it's-
well,
they-
no, but it's.
They just changed it around, but it's
Yeah.
basically the same intent.
Okay.
We get to sell it to a third party if we want.
And are there any cases of them having done that?
Not that I know yet.
Because
No. We're watching.
We'll get to that in a minute,
Yeah.
because I'll talk about that.
Can I ask a follow-up?
Yeah, so over there first, and then I'll come right back to you. Yeah.
It happened to me that I posted some images on my personal photography page on Facebook. Then the images were downloaded by a company and re-uploaded without my knowledge. And they were promoting their business with my images. And I caught them. And so we're now talking. Because basically I feel that they stole my images. They should have shared them. They should have given me a credit, or they should have said something that they came from me, because that's what social media is all about, is sharing,
Right.
so that people know who is the original creator,
Sure.
so that they can link back to me.
Right.
That's why I'm posting on Facebook.
Mhm.
Otherwise, why would I do it?
Right.
So, is that illegal what they did?
It sounds it, I mean, I'd have to think.
I mean,
through the
it's a
fact
big
that-
company that did it.
Yeah, it's not, so this happens a lot, because a lot of the social media groups in these big companies are run by people right out of college who know how to use social media,
Yeah.
and they don't know anything about this stuff.
Yeah.
So they end up ripping off pictures and just doing whatever they want. That does sound like a problem, and I'm glad to hear that you're talking with them. As far as what you can do and how to respond to that, we'll get into that a little bit later about your options. I mean, ultimately, the option is to sue, but as I mentioned earlier, you can't do that unless the work's been registered.
Yeah, I registered my
Okay,
work,
good.
but after the fact. I
Yeah,
mean,
that's
I
okay.
registered, yeah.
So you may not end up, so what typically happens with the registration is if you registered after the infringement happened, you wouldn't be eligible for the statutory damages and recovery of attorney's fees that we talked about earlier. But what you do have now is a registration certificate. And you can send that along with a nasty letter and say, hey, look, I registered this work and I'm going to sue you if you don't pay up or do whatever the issues are. If they're smart, they'll come back and say, we see that, but the infringement happened before the registration. You're not entitled to statutory damages and attorney's fees and you don't care. And unfortunately, that's the reality, is that most infringements get blown off. Either the photographer doesn't take steps to enforce, you have taken steps to enforce, but the recipient just doesn't care. And it's a big problem. And there isn't, I don't have a firm answer as far as how to resolve it, unfortunately. But the fact that you're talking to them is you're already miles ahead of where most people are. So, we have, sorry.
What takes precedent if you put it in an exhibit,
Mhm.
or if you copyright it before it's on exhibition?
Sorry, say that one more time. Say the first
I
one.
want to know whether if it's copyrighted before it goes on exhibition, whether that becomes the idea whether it's published or unpublished,
Oh, I
or
see.
once you put it on exhibition or put it somewhere
I
online.
think another way maybe to state that is, if the publication status changes after I've registered it, do I have to re-register? No. And that's why I suggest registering everything when it's clear that it's unpublished, just so you can, there's no question. So before you have an exhibition, you register all that work, and then you put it on display. That registration covers all that work. So you don't need to worry about re-registering.
Whatever you do first is what.
This distinction, the only people that care about this are the photographer, the copyright office, and the defendant if it's infringed, because they're going to argue you did it wrong. They will always argue you did it wrong. That's just how it works, right? That's their job as defense attorneys, is to say that you did it wrong and defeat your registration. So, yes.
What's how does it affect me as a photographer if the image is published or not? Like
It does.
down the line legally, if it's done incorrectly, is it just get them out of a law case?
Yeah, so usually the way it goes is you're suing me for infringement. And I see your infringement lawsuit, but your and I thank you for your registration. Usually the way it goes is, thank you for your letter about the infringement, but your work's not registered, and so we don't know that you actually own it. You say, oh look, here's the registration certificate, I own it. I turn around and say, thank you very much for your registration certificate, I think you did it wrong. Your registration is invalid, it's actually not registered. And all that happened, and that's what happened in that Alaska stock case that I had a quote from earlier about the Copyright Office. And that was the whole issue, is they went all the way up to the Ninth Circuit with it, was whether the registration was valid or not. And what they had a bigger, they were trying to set some precedent because they wanted that, the publisher wanted to try to keep all these group registrations basically because the business practice was to routinely overshoot the licenses. So they had a lot of money at stake if they did.
So is it just a procedural thing, or is there something where I've given up something by, if something has already been published when I register it, have I given up some rights?
No, in fact, I think, frankly, if you are ever unsure, you're better off registering as published, because to register as published, you actually have to provide a little more information, which I'll get into in a minute, and it strengthens the public record. And all of this, at the end of the day, the policy drivers behind having a registration system in the first place are to provide the public with notice of your registration claim. So the more information you can provide on that registration, the better, and with published, you have to provide more information. So if you're uncertain, published is probably a safer way to go. The other thing you do is do something to publish it, and then register. And then you have, within the 90 days, and then you have, you're good, because you can establish that it was published. So,
But you have to know the date that it was published, right?
yes, you have to know the date of first publication, which is another thing they'll try to defeat you on. Again, this is all why I promote registering as soon as it's off the camera, still unpublished, no questions, clearly unpublished at the time. So, quick follow-up and then up here, because you've been waiting for
Why the distinction? Why did it?
we'll get to that in a minute. Okay, so that's my next slide. It is relevant. It's a fair question, especially in the digital world, but it is still relevant. So, yes.
If I take my images and create, for example, a blurred book,
Mhm.
does that make it published?
Yeah, you sell your book or just for yourself?
If I need to sell it to my sister,
I would lean toward, I'd have to think about it. Just my gut reaction. Because you've given, actually, yeah, because you've given, by doing that, you've uploaded it to Blur. Blur now has a license to do what they need to do with that work to make the book. So that's, I haven't read Blur's terms of service, but my strong suspicion is there's a very broad clause in there that says we can do whatever we need to do with your image to create the book. And that's, yeah, it's pretty, if they're responsible, it's limited to what we need to do to make the book. Yeah. If they're irresponsible, like an Instagram, they may have other rights, but I haven't heard any negative stuff about Blur, so I suspect they're okay. But even that limited license to make the book is, I think, probably sufficient to make it.
So what do you do, and I'm sorry I came late, so maybe you talked about it already.
Mhm.
If I take a picture with my phone, I post it on Instagram, automatically it goes onto Facebook.
Yeah.
How can I register it right there and then? Because Instagram is about instant. And
So
What do you-
the short answer to the question is you can't register it right away from your phone. There are some companies that I know of that are trying to build that functionality into software, but the problem is the thing I mentioned earlier, is the Copyright Office systems can't support any of that yet. So it would be great if you could, in Instagram, after you do all your tweaks and hit publish, you just check a box at the bottom that says also register this work with the Copyright Office. And you've already put into it, assume you've already put in the details and stuff. There are companies that want to do that, a lot of them, and they used to come lobbies at the Copyright Office to ask for this API. People are getting really impatient with the Copyright Office, and now I know of a couple companies that are just building their own API, and they're going to show up at the Copyright Office door and say, "We have an API, give us access." But right now, you have to go through this. You have to go through an annual process of taking the image from the phone and going through some of the steps I'm going to show you. I know that's not a very satisfying answer, but that's unfortunately it's the standard.
I think generally where we're looking at the industry now is don't do anything on Instagram or Facebook that you don't want ripped off. It's just the end of the day. Just don't put or high enough res or anything. If you have a high-res photograph, take a picture of it with your iPhone and post it if you have to. Don't put the actual, it's low res anyway, but we're at a point now where, we're all pulling our hair out over it, but at the end of the day, don't put anything up that you can't live with getting ripped off on Facebook, on Instagram. And that's
But
just
if it's gonna be reposted on Facebook and Instagram, the quality almost doesn't matter.
right. No, well,
That's your
yes and
point.
no. Yeah, yes and no. I mean, you could make it really bad quality, just like what I did is I just had some personal work that I just photographed it on the wall. That takes it down even a notch further. So it's a reproduction of a reproduction.
It kind of depends, I get into this a little bit later, but all of this really depends on what your goal is. Like if you're using Instagram, like I was reading or heard a podcast the other day with somebody whose entire business is on Instagram. That's how this photographer makes money. Versus using it as a tool to promote your work. And if you're using it as a tool to promote your work, to me that's very different. I mean, the kind of thing you're doing where you shoot something on the wall, that's sufficient for that. It may not be sufficient if you're doing Instagram, or sorry, business like if that's your business model. Yeah, yeah. I think I was on the Apple podcast, but I think they were selling they were a travel photographer and they were selling like destination photography to convention and visitors bureaus, and then using the networking as sort of because she has a following, so using that as the value. So arguably the value's not in the photograph, it's in the network, right? But it's all this what you know, we're not actually doing anything. So yeah.
Do you remember that photographer's name?
I don't, but I can tell you, it was on This Week in Photo just launched a network of podcasts, and they have one called War Itinerary. I think it was on that podcast. It was a couple weeks ago. Yeah, sorry, I don't remember the exact name. So I hesitate to ask this, but are there any other questions? Or are we as clear as we can be for right
So
now?
posting on your blog is not publishing either.
Well, it depends. So I think the Copyright Office would say, if you have a notice on your on your blog that says, "Don't take my pictures," and it, you know, it depends how strong you want to be. I talk later about some principles of sharing online, and one of them is be reasonable. And then I've seen a lot of photographers that have these like really grouchy, nasty images, nasty pages that you have to click through about how I'm going to sue you and take your firstborn if you copy my images, and this is how I make my money, and don't steal my stuff. And I get it, like everyone's frustrated with this, but that to me just ticks people off. So going that far is probably, I mean, I think it's a little much, but if you have a copyright statement on there that says, this work's mine, I really appreciate your interest, but please don't take it, I think that's enough. I think that the Copyright Office would consider that sufficient to determine it on public.
How about just putting watermarks on it?
Yeah, well, so I'll talk about that later. And I wrote in the sort of the sharing portion of all this, I'll talk about this, the third phase of the workflow. I will talk about some things we can do, because I like to characterize it, to make it a little bit harder to steal. Because the reality is, somebody said earlier, like once it's on the internet, it's going to get ripped off. And so what we can do is apply certain little things at the margins, like watermarks and borders around it, to protect it. And then I think you're saying you can use that as a way to make it published, unpublished. That's probably, if it says that it's copyrighted on here, you're probably okay. You're probably okay. But as I said, and I will say it one more time, none of this really matters if you register as soon as it comes off of the camera, because it's definitely unpublished at that point. Almost certainly unpublished at that point. And I realize that's not helpful for those of you that have large catalogs of past images that you need to register. That can be very tricky, because then you do have to figure out which ones are published and which ones aren't, and register them. And that's why you should build this into your workflow. Which is why we're here. Here are the reasons why determining whether it's published or unpublished, whether it's published or unpublished. I mentioned one of them earlier, that if it's a work for hire, the duration of the copyright is based on whether the work is published or unpublished. Deposit requirements differ. Photographers don't need to worry about this one too much, but it's more with literary works. So there's actually a piece of copyright law that very few people know about that requires, regardless of whether you register your copyright or not, if you publish a work in the United States, you basically have to send 2 copies to the Library of Congress. That's where all the books come from. They get them free because you're required by law to send them to them. It's a little more complicated than that, but if it's unpublished, what you have to send to the Copyright Office or to the library is very different than if it's published, so that's relevant. Certain limitations and exceptions rely on that distinction. So in the fair use context, we might think about published works will be given less protection under fair use analysis than unpublished works. And then there's some other limitations and exceptions that only apply to published works. So that's why it's still relevant. For visual artists, it's kind of marginal, but it would be a bad idea, I think, to remove it from the Copyright Act, which is what for a while. A couple of associations were advising, and that to me is just there are larger systemic issues with doing that that are sort of beyond photographers. So one of the frustrations with copyright law generally, and with the Copyright Office specifically, is that it has to be all things to all people. There's lots of different types of creativity, and we think about it in terms of visual artists, which, as I've said before, in fairness, are the ones that I think get the short end of the stick with a lot of this stuff. But we're not the only ones out there, and so the system has to work for everybody, and that's where some of these tensions lie. Is that we're trying to create a system that works for everybody, and so doing this creative one that doesn't work for everybody. But again, we're working on it. All right, so we're going to move on to the middle section, and I'm going to actually go through, we've been going for about an hour now, so I'm going to run through this one fairly quickly, because this is the part where I said there's lots of other resources, so I'm going to give you a flavor for the approach that I take, and then I'm happy to take questions, and then we'll get into the more of the sharing and online stuff, because I think that's where there's some interest. These two, image capture, image import, you all know how to do that, and we've already talked about how you can get the copyright information into the image at that stage. We're now going to move on to these last sections, image registration, and maintaining records, and I'll touch on updating stuff, although I kind of already mentioned the Copyright Office makes that very difficult to do, unfortunately, with the public record at least. So, let's assume we've figured out whether we're published or unpublished, and we figured out our registration strategy from the earlier part of the presentation. Now we need to decide how we're going to register. Basically, you can do everything online except for published groups, which still require that you file on paper. I remember that. It's very trite. P published, P paper. And they P published. So here, interestingly, they put the fees up last year, but they kept this one at $65. I think they only put this one up like $10 or something, because they're trying to, obviously, price people out of filing on paper for normal registration, but they recognize that the published groups, that's the only way you can do it, because their system won't accommodate it online. So as a bone to photographers, they kept this one at $65. I appreciate that that's still a lot of money for many people, particularly what the photography industry is doing right now. But remember what I was saying earlier about the need to keep the system going. It's a really difficult balancing act for the folks at the Copyright Office to charge what they need to charge and also provide the service they need to provide. So single image, I'm not going to spend a lot of time on that, although I do have an example. So these are actual records in the Copyright Office database that exist right now. You can go home and look these up and see what see these in the database. I'm not going to spend too much time on this. Standard issue registration, there's a title, the ownership information, the names under which it's registered. Mine are a little confusing because I register under this company name, and I'm not going to get into it. That's like registration 2.0, why I do it that way. We'll skip that, but this is what a basic record looks like for single one. And the most important part here are the application number and the effective date of registration. This is the date that the Copyright Office receives all three elements of the application in final registerable form, not the day they get to it. We'll see why that is in a minute. So this means that on February 26, 2013, they received from me the fee, the completed application, and the deposit copy, the copy that you have to send them so they can look at it to see if it's copyrighted or not. That's important because that is the date on which you register, and remember the 3 months and all that. That's very useful. Some rules. These are the part I'm going to kind of fly through this part just because they're, like I said, this is written down in a lot of places, but just so we're all kind of on the same page. If you have a collection of unpublished photographs, not a italicized collection, because remember, these are terms of art. So if it's unpublished, so these are batch registrations now. We have multiple images on one form. It's unpublished, it's a collection. And the requirements for a collection are that you have a single overarching title. So that's like earlier I said mine are, Chris Reed Photography, and then in parens something. That's the overarching title. The copyright claimant has to be the same for all of the images in the collection. So that's pretty straightforward. And then all of the images have to be by the same author. Again, if you're a single photographer shooting for yourself and you're in business for yourself, these two are pretty easy to do. And this is what a record looks like. I'm using the records as opposed to the applications to show you what this looks like, because the data is all there. It's just the application form's not particularly user-friendly, so I figured I'd do it this way. This is an example of an unpublished collection that I filed on January 3rd this year. It's all the photos. It's just my holiday trip 2014. What's the other thing I wanted to point out? So when you do collections or groups. There is a field on the application for contents title, or I think in some places it's abbreviated as COTI. There are lots of different views about how to do this. I do not want to give each of my 268 images a title, and even if I use, some people will use the image number from the camera, so the cameras all have their own numbering system. I think some customize it actually. You could, if you wanted to, in these contents titles field, put in each of those images. To have the strongest registration, that's probably the best thing to do. For most of us, this in some ways is a bad example because there's only 268. Some of mine, I think the next one has like 900 images in it or something. Again, remember, none of this is automated, so I would have to key in each one of those titles or each one of those image numbers, and I just don't have time to do that. You might have time to do that, and you might want to do that for some situations. All of this is about balancing risk and reward. So, is this a perfect registration? I don't really know until court decides. I think this one's pretty good because I'm describing, this line is required, these two are sort of optional. This line tells the Copyright Office and the public who's looking at this record that Chris Reed Photography Holidays 2014 is an unpublished collection with 268 images in it. These next two I include because I want somebody, a court, down the road, if one of these images is infringed, I want them to be able to look at the deposit that's on file at the Copyright Office and the registration record and see that it is my images from my iPhone that were numbered this through this, and then my images from my SLR camera that were numbered that through that. And this is the naming scheme. In Lightroom, I have it update the file names and everything. And this, I was in Sacramento for the holidays, so that's why they're called Sacramento and those numbers. But this gives you and the public and courts a better sense of what is actually included in Holidays 2014. Because one of the problems, one of the arguments that came up in that Alaska stock case I talked about earlier, was they just were filing registrations that said 1,000 images from these 5 photographers. And that was it. And so you kind of understand why the publisher was like, hold on, that's not a legitimate registration. You're telling me I'm liable for $150,000 per work infringed, which is the top of the statutory damages range, for each image that's in this like massive images you submitted, and I have no idea telling what's in there. And so to sort of push back on that a little bit, I've started telling the Copyright Office and the courts what's in there. But I haven't gone so far as to do it on an image-by-image basis, because I've just made the decision that it's not worth my time to do that. You may have a different, that may shake out differently for you. This is going back to the ground rules slide. It's not prescriptive. You do it however you think makes sense. I've had a couple where I have articulated each of the images because they were important, and I wanted to make sure that our record is very, very clear. Yeah.
But when you upload the images, they each have got a title.
Yes, so we'll get to how I do the upload in a minute, because I don't do it by, I upload like a contact sheet kind of thing, which has each image name on it. So I'll show you that. We'll get to that.
And if one were to choose to put the file, actual camera file number into the contents page, any workflow suggestions on how to get that data, or is there a cut and paste thing, or is there a way to list out?
There's, yeah, you can use, so some of the software has batch rename, type the bridge, you're saying, you can do that? Okay. I mean, Lightroom probably can too. John Harrington, who is a photographer based in Washington, has a book that just came out. He has 2 books, but the second of this came out. I think it's called More Best Business Practices for Photographers. It's from Cengage Learning. He has a whole chapter in there of how to do that, to put each in, because he's of the view, this is where we get into reasonable minds and differ, he's of the view that this is not good enough, and that he wants to articulate each and every image. And in fairness, his images are probably worth a lot more than mine. He used to be the head of the White House Press Photographers Association, so he's got some really, got a lot of Washington stock kind of stuff. He's come up with a way to do that again, is not perfect, largely because the Copyright Office system doesn't work that well. But he articulates that in the book, and it's chapter 20-something, I think. And you can, again, with John Harrington, it just came out last year. Should be easy to find. All right, so that was unpublished. I'm going to just quickly go through the process for published. And again, remember, because we're published, we're talking about groups, not collections anymore. And for this, the requirements are really very similar. Copyright owner has to be the same for each image. Photographer must be the same for each image. The public case, so here's where you add some layers because we're talking about published. You have to have, the publication date has to be within the same calendar year. So somebody mentioned earlier when I asked that question about what if I'm doing periodic registration, what's something I need to keep in mind? And someone said, use the year. For published work, you would have to. because that's a requirement for Copyright Office. And then this is the part that really trips a lot of people up. Somebody mentioned earlier, you have to be able to identify the date of first publication for each image, which can be tricky. It's especially annoying because I understand that there's no metadata field in any metadata schema that I'm aware of that includes date of first publication. But Plus might actually. There's an organization that's created their own metadata scheme, and that actually, now that I'm thinking out loud, may include that, but we'll talk about Plus a little bit.
Okay, quick question on that.
Yeah.
If first publication was a gallery exhibition, could the invite and so forth
Yeah, no,
be,
yeah.
be
So-
legitimate?
Absolutely, yeah. So the issue with most photographers is they just don't know. But if you've got something like that that's very clear that that was the date they were first made available to the public, then yeah, I think that's sufficient.
And you can send hard copies of that in with it, or just
No.
scan it?
So this is an important point actually, is that all of this, this published, unpublished stuff is self-reported. So they're not going to, the Copyright Office is not going to push back. They might ask a question or two to confirm that you, like, if there's some question, if something's missing on the application, they might call or write to you to confirm something, but they're not going to question your decision. So if you just made that argument if I'm with the Copyright Office and I call to say, well, how do you know about the first publication? And you say it was the date my gallery would show open, they'll leave you alone, that's fine. That nobody's going to question it. Where it becomes an issue is if you're sued, or if you're suing rather, and the defense says your registration's invalid, it becomes a question. But that, your gallery invitation, I think that's more than sufficient to establish the date. So,
Yeah, what if you register something that's unpublished, but then you think later, oh my God, I think I published it earlier than that?
you can, that's a good question. There is a mechanism by which you can file a correction or amplification to the record. It's Form CA, only on paper, and it's $100. Yeah. Incidentally, that's also the form you have to file to change your address, that's why nobody does it.
Is that $100 per image?
You want the strongest possible record? Yes. You file one form for each image. You can, the Form CA, I don't have a copy of it unfortunately, but it's basically a free form. You have to identify the work based on the registration number, but then you can kind of free form in what you're correcting or amplifying on the record, and you could probably get, if they're registered under one registration number, like a group or something, published group, you would be able to, I guess you could list them every.
Even though they each may have different publication dates?
Yeah, you want to be really clear about what images you're talking about.
Okay.
But I think there's probably a way you can do it. So, the other problem with Form CA is none of that information makes it into the record. So if you file Form CA to change your address, for example, you pay your $100. Actually, with addresses, they were trying to do updates, but it's manual. There's a person who's Sue Austin who sits there and types them all in her free time. When I started in the Copyright Office in 2011, January 2011, there were still desks with her.
Awesome.
2011. They only converted to electronic processing in 2007, to give you a sense of how things are. So yeah, and I'm bashing the Copyright Office a lot, but it really is, it is, some of it is institutional inertia, and they take responsibility for that, but a lot of it is just decades of institutional neglect by the Library of Congress, which is the steward of the Copyright Office. And that's a hot issue right now, is whether that's the appropriate place to have the Copyright Office. And we could talk for days about that, and are in fact having conversations over many days on that very topic. My view very strongly is that it should not be part of the Copyright of the Library of Congress anymore, for a variety of reasons. All right, so back on, this is an example of the record and published group. The main difference here is that you, on the record itself, you have to provide a range of publication dates, which is there. This note, CO correspondence, that means I screwed something up somewhere along the line. They had to write to me. And I think actually in the book I have the screenshot of the email, just so people don't freak out about it. The correspondence with Copyright Office is not that bad. Yeah.
Quick question,
Sure.
the registration dates in terms of the final date, would that be the run of the magazine, or if it's a monthly publication? Or?
Yeah. Well, oh, you asked about like why this says range of publication?
Yeah, why not just the first date? Why do you need to include the date?
I think technically you can put the first date, but this was a, different images in this group had different dates of publication, and I wanted to just make that clear because I knew, I worked there, that this would end up on the record. whereas the dates of the individual images would not. And I just wanted to make it very clear that that not every image in this group was published on 323 or on 1030. So I think I've seen some people where they'll say first publication, group first publication as early as or as late as, and I think that passes muster as well. But again, it's one of those things where it's not an issue until it becomes an issue. So it depends on how clear you want the record to be. Yeah.
Let's say I have 10 publications in a year.
Mhm.
So you made it sound like group registration, published photographs. So you do not name them individually.
You can, and well, we'll talk. So in a minute, I will. This is a paper application, and I'll show you how you do that on paper form. The problem is, so this is, remember back to that chart I showed you a few minutes ago, and paper published. These have to be done on paper, and the way we can tell is it says up here description of the deposit as a CD or DVD, and then the electronic ones will say e-service, description e-service. That means I use the online system. So you can tell from the record, probably don't need to ever do this, but you can see here where it says CD, DVD, you can I lost my train of thought, but you can see that it was a CD or DVD.
So it's done on paper, but you are submitting it on a CD.
Yeah, so you submit the paper form along with a CD that
Yeah.
contains the deposit images. And someone was just asking about image names and all that. I'm going to get into that here in just a second. All right, this is the sort of thing that you can find elsewhere. But just for completeness, the registration portal, that's the address we get straight to the registration portal for online registrations. And remember, you can do that for unpublished collections and single images, but not for published groups. And it looks, this is the part I was saying I'm going to kind of skip over. I'm going to show a few screenshots of the process, but I really want to go through screen by screen because frankly it's boring. And it actually, I mean, getting side, it's actually pretty straightforward. Once you get in there, it's just a little clunky and it doesn't work the way you would expect websites in 2015 to work. But that's the creating an account, you create an account. Then you get to this screen, which is sort of the first page of an application. Once you tell it the type of work, it will restructure the application to ask you the right questions. This is an attempt at showing you where you are in the process, but it doesn't always work properly. If anyone's done like an insurance, bought insurance online or something, they're a lot better at that. Where they'll say, now you're going to tell me about the drivers, now you're going to tell me about the car, and they like walk you through it. It's all very clean. This is supposed to be that, but it's going. So it looks like that. It will then bounce you to another site to pay the bill. This is a site called, I forget what it's called, but it's run by the Treasury. And it looks like this. You can pay, the easiest way to pay is with a check, which is actually pretty convenient, or a credit card. No additional fees or anything like that. It's up to you how you pay. The other, if you're a high volume remitter, as they say, or somebody who files a lot of copyright registrations, you can actually open a deposit account with the Copyright Office, where they put your money on account and then you draw down as you apply. So like I work for One Studios, and we do that. We'll send them a check for 20 grand every so often, and then we'll just draw down from that. So we don't have to cut a check every time we register a new screen. I don't do that for my own personal work, but it's an option if you're filing a lot. All right, so this is an example of how I create a deposit for a unpublished collection. And it's pretty, this is where there's like a lot of screenshots in between, but I just wanted to give you a sense of how this works. Using the print module in Lightroom, I have set up what is basically a contact sheet. It is up to you how big you want them, but they need to be big enough so that the Copyright Office can see that it is an image. They don't necessarily need to see all the detail, but they need to see enough of it that if somebody showed up to court later and you needed to show that that was your image, that there's enough detail there for you to see that. So quite honestly, like, this is a 4x5. I think on my last one I increased it a little bit. I output this to a PDF, so I'm not saying it doesn't really matter at the end of the day. How many pages it is, but obviously the bigger you make the image, the more pages it's going to be. And then I make sure to put the image number at the bottom here, and that, you remember on the, when I showed you the clip of the record earlier, it said it's, images this through this. Those match up so that you can see that the first image here is called whatever it was in the record, and then we go to the last page, and you see the last image there. So we can marry the record, the application information, which becomes part of the public record, with the deposit copy. So I output that to PDF, and then unfortunately, I have not played with Lightroom 6 yet, which just came out this week. So it may do a better job at headings and stuff, but I was never satisfied with the annotations that Lightroom could make on contact sheets. So then I take it into after that, and I add headers and footers. And again, just to make sure that everything's properly connected, I take this number, which is generated by the online registration system. It's called a case number. It's also sometimes referred to as an SR number, a service request number. And I put that at the top along with that overarching title for the whole collection, and then the page numbers. And then I send that PDF to the copyright office. That's the deposit. Lots of questions.
The case number, does that come when you first?
Yeah, if you, right up there. So as soon as
You fill out this data first, then go to the Lightroom.
there's a screen, yeah, exactly. I do the application first, and a couple of these slides are probably not in the greatest order. You can do the application and pay for the application, and then it takes you to an upload page, and you can come back to that whenever you want. You don't even have to upload right away, so you can take a day or two or whatever. Remember though, your effective date of registration is when all three, the payment, the application, and the deposit, get to the copyright office. So your date won't be set until the deposit's uploaded. So you can wait as long as you want, but if you want to preserve your registration date to be as early as possible, you want to upload it as soon as possible. But it's two separate sort of steps.
Yeah, I heard somewhere that the picture has to be big enough so that you could show it in court and people could make things out.
Yeah, I mean, that's certainly, yes. I mean, that's probably a better practice than this. Again, it's one of those things that's not a problem until it's a problem. I've decided that this is sufficient for my purposes. You might not agree with that, and you may want to do, 2-up or something like that, or have 100-page deposits. Totally up to you. And if you're concerned about it, fine. I'm a lawyer, and I know that most of these things settle long before you ever get to court. And so, I'm not too careful. I'm very cynical, and I know that really I'm doing this to get a registration certificate so I can send the nasty letter to the infringer and say, don't do this anymore. The likelihood of that being an issue in court is pretty slim, but you're absolutely right. That's ultimately what you have to keep in mind. Is this is all about what's going to happen in litigation down the road. So that's a fair criticism of this approach.
Sometimes some of my images have got different names. The same image, if I register to some contest or put it up for a series, I change the name. So is that going to be a problem?
It's kind of up to you how you. So like when you name the image in the system, you're wondering which one to use, basically. Like if you call the image certain.
After the image is taken, I can sometimes register to a contest and then ask for a name. And then I give it a name, but then sometimes I change the name.
Yep. So what I would do is when you put in if you're going to name the individual images in the registration, you can, in those contents titles field, you can add those additional titles and say, there's a field for, within contents title, there's a field for alternative titles, and you can put in the other names there. And that way,
if I put the submission before and the name comes later.
So technically, you would want to file that Form CA that I was talking about earlier. Whether it's worth the $100 to do that is totally up to you. But that's to make the record as complete and robust. That's what you do.
How important is the title if the image matches?
I'm not entirely convinced. The Copyright Office doesn't care one way or the other. Like they don't. The image numbers for them are fine. Gets a little tricky with image numbers because cameras, like if you have two cameras, they're generating sequential numbers and then you can get duplicates and stuff. But generally speaking, they don't care one way or the other. Like that, I think I had a sample record from an image I took called Lone Star State. It's a shot of the Texas State Capitol. I made that into a series of other states, and so I renamed that one Texas. And so, but I've never bothered to I don't think anybody cares. Like if you're looking at the two images, I always hesitate to say things in absolute terms, but I think it's unlikely that a case would probably fall on what you're trying to do. So it's possible, but I don't think it's very likely. Not likely enough for me to file that Form CA and pay for it. But again, just to be clear, that's me because this is not my full-time income source. A company like I work for, a studio, would absolutely pay $100 because it's, we billed 31 million last year, I think, or $1 billion last year, so $100 to file Form CA is not going to get right. So, and you're looking at properties that are worth hundreds of millions of dollars on their own, whereas my image is the Texas State houses. So this is not where it's all about this balance. Those are business questions. Those aren't individual questions. It's just how much risk tolerance you want to take on the knowledge.
Right.
So that's what a finished sort of deposit sheet looks like. I actually think the detail's pretty good in this, and obviously we're projecting it. Even projected though, I think it's pretty decent. I'd be comfortable introducing that in court, but you know, I could probably go off the sides. As I said, like earlier, I think my latest one I did 4x4 or something like that. I mean, something to make the images a little bigger. And then this was you were asking earlier about the this is the upload screen where you file. This actually, I'm just reminded now, they updated the upload software back in January, and it looks a little different now, but basically like this. It's still a multi-step process. So basically we have the application, the payment, and the deposit, and they're all 3 different steps. And you'll get a confirmation email after each one. But this was the part I was saying you can wait till later to do if you want to. So I'll do the application, get the SR number so I can put it on the deposit, and then upload the PDF. And I'm uploading one file because they're all on that PDF that I showed you earlier. I don't have to mess around with uploading each individual image. Some photographers have run into problems with, they'll zip the images, they'll do individual images, image files, compress them into a zip file, upload it. There's a file size limitation, which I forget what it is now. Yeah, so this is actually confusing. There is not a file size limitation, but there is a session limitation. So it depends on how fast your internet connection is, how fast the copyright office's internet connection is, how fast their triage server that scans for viruses and stuff is going. There's lots of different reasons why it may not take your upload. And so that's why I use the PDF that just makes it a little bit.
It's 500 gigabyte per zip
500
file. Yeah,
gigabytes?
yeah, 500 gigabyte.
Oh, okay, then that's substantially bigger than it ever used to be. So, okay. So that's...
No, I'm
that's
sorry, megabyte.
Megabytes?
Megabyte, 500
That makes more sense. That's still bigger than I thought it would be.
Yeah.
That makes a lot more sense.
I just did.
One of the problems we had was how to handle digital movies, because movies now are all done electronically on hard drives, and they don't have the capacity to handle it. So we're still, the film industry is still striking old-fashioned prints just for copyright rights. To several $1,000. Not cheap. So, all right, paper forms. You can still use the paper form for anything, but you don't have to, and because it costs more. I wouldn't recommend it. But you have to use it, remember, for published groups. So we're just gonna, you can download them from the website. It looks like this is Form VA, which is the one you use for visual arts. It's the same questions you're asked on the website, but it's a paper form. The additional piece you need for published works is called Form GRPPH Con. Rolls right off the tongue. It's also on the website, and it's basically this. It's basically a list of each image. And this is why it's so laborious to register as published, but your record is stronger because you're providing all this additional information. Little key feature of this form is that they have not set this text field properly, and so you can't read it. And so what I end up doing is I strike that, and I will write it in over there once I print the form. Because remember, paper application, you're mailing this in, so you have to print this out. You can fill it out online, which is a big step for the copyright office. What's that?
Nobody can fix that?
Oh, I guarantee you somebody can fix it, but it's not their job, so they haven't done it. So, what's that?
It's not nice.
Yeah, no, that's a common mantra. Copyright as a library. So you have to provide this information. I've put in descriptions because this whole batch was this, so it was easy to do that, cut and paste situation. This is completely optional, as it says. These fields are not. So you have to give this, and again, this is why it's so laborious to be doing published work. So you have to give each one a title, which here it's just the file name, the date of first publication, which I think was the day I uploaded to PhotoShelter. And my reasoning was, I have PhotoShelter set so that it would allow the family members that I gave access to that site to order prints. I considered that published because they could buy copies of them, right? So I assumed that was published and registered as published, which wasn't a big deal here because these images were all the same thing, so the answers were all pretty much the same. But that's what you have to do. That's, like I said, this continuation sheet. There's a limit of 750 images in a group register. There's a limit of 750 images on the continuation sheet. So you're basically, as a practical matter, you're limited to 750 images for paper demonstration.
Jumping back to the first publication, when in doubt, should you err on the early side of that, check yourself? Or can that be challenged?
Yeah, it can all be challenged. I'd have to think through. I think so. I'd have to think through the implications of that. But yeah, I think that's right. I'd err on the early side.
And if I'm selling, licensing an image to a magazine, is it further July thing?
I would consider the date of the license.
The date of my contract with the,
Because that's the date you made it available for sale and surrender, all that, section 101 definition stuff. So, all right, so let's talk about very quickly about the deposit that I send in paper form. You saw earlier on the record it mentioned CDs and DVDs. That's what I send in. I generate an image using Lightroom and the plugin. The name escapes me at the moment, but there are lots of ways of doing this. It adds this border that's contextual, so it adds the file name of that particular image to this, and it adds the date of first publication. This part is only semi-manual because what I had to do was if you have images within a group that were published on different days, you have to update that each time. So like I could generate this image, the deposit image, for like all the images published on 6/27, and then I had to go in and update the settings in the plugin to all the images that were first published on 6/28, and then run those, and then on 6/29, and run those. And so it's still labor intensive, but it's easier than the alternative, which would be to generate something. Well, I shouldn't say it's easier than the alternative. The alternative is to just send in the images, right, with the file names as the title. I like to do something to connect the information on the face of the image with the information that I provided on the application. Again, with an eye towards creating a strong public record of the copyright. The first, and then this one up here says that overarching title. Opinions vary on the resolution. I think these are 600 by 600 for the purpose. This one's bigger for purposes of protection, but the ones I send to the copyright office are fairly small. And then again, add that, stick them all on a DVD, label the DVD with the case number that we've talked about a couple times before. No, sorry, with paper, so we don't have a case number. But with the title that's on the application. We want to make sure those two are connected so that when it gets lost, things often get lost at the copyright office, they'll be able to put it back together. So then what happens? Eventually, you will get a registration certificate. And right now, and I was actually horrified to see this, I didn't realize it was this bad. 8 months now for electronic applications and up to 13 months for paper applications. The paper hasn't slipped too much, but when I left the Copyright Office a year ago, that was 3 months. So I'll be very honest, I'm not sure if some of that may be, Copyright Office budget's been a hot topic on the Hill lately, and I'm wondering if some of that is done for political reasons so that they can show.
Well, I'm 6 months out, still waiting.
Are you? Yeah, okay, so it's actually.
Recent, re-registration.
Okay, all right, so but you're still waiting, you said?
Still waiting.
Okay, because I was definitely getting, I did one a few weeks ago, and it turned around really fast, but I think that may be because they know. Because they remember. But because I know when I was there, stuff always turned around really fast as well.
But you could be putting that in for arguments.
Yeah, I think, that's just straight off the website, so it could be, often what happens is, they're big fans of the, under promise over deliver. So, they may be manipulating a little bit. Anyway, I've shown you what the online record looks like. This is what the physical certificate looks like. They still mail paper certificates out. They look like this. What do you do with that? I scan it and then put it on, I'm a little obsessed with record keeping, so I will scan it, call the file name, I think it's Lone Star State, and then the registration number, and then I put that in the same folder as the deposit to which it pertains, so that I have them all there. So this is a single image, so there's a JPEG called the same thing as what I call this file on my hard drive somewhere. And for the group registrations, I have to PDF, put that together. The other thing I do then is update the metadata in my software. This is one of these areas where people argue with me. I, for a long time, was just using the job identifier field because I wasn't personally using the job identifier field for anything else. It's an IPTC standard field. I realize there are many of you that may need that field for actual, job identification, or you're selling licensing works to people that need that field for free or whatever. And so this has some risk to it. Fortunately, Plus, the full name of which is Picture Licensing something. It's Jeff Sedlick's group, if anyone knows Jeff.
Plus.
What does it stand for?
Picture Licensing Universal System.
Yeah, that's right. Okay, Picture Licensing Universal System. It's their own, rolls right off the tongue, just have to continue. And it's basically another metadata schema that allows you to put in additional information, like the copyright registration number. So you can get this plugin. It's not free. I think it's $50. So it's not outrageous, but it's not cheap either. And you can get it. That sits right within Lightroom, and you can input all that information directly in there, and it goes with the image. One problem with that, just one second. One problem with that is that not everybody has systems. You can only reveal that if the people you're talking to also have something that reads Plus. And it's becoming more universally accepted, but it's not 100% yet.
What is the name?
It's Plus. If you go to useplus.org, it explains everything more than you ever want to know about it. It's a metadata. It's basically a standard for licensing, for communicating information about images with an eye towards licensing. But one of the things they've done is created this metadata scheme that includes the copyright registration number, which is why it's relevant to us. There's a question.
Yeah, is there an IPTC place or location for that type of information?
No, and that's why I resorted to the job identifiers, because there is nowhere in the standard fields to do that, and that's why Plus had to come along and create it. So, and I don't know why. I mean, IPTC was created for professional use, so I don't really understand why that's the case. But,
so you couldn't put in the copyright information?
you could. It's just that what happens is a lot of software when you develop, if you put in, if I'm generating output and I want it to include a copyright notice, usually you don't want the copyright registration number in the notice, and it uses that field to pull from when it does the notices. And actually, I don't even like the data there because the output, the way Lightroom generates that field, it puts the data in twice. I've lost track of exactly what it does, but it doesn't work the way you'd expect it to. So I've resorted to leaving that out. Again, somebody asked earlier about that with the camera. The date's in there somewhere else. The capture date and time is in there somewhere else, so I don't need to worry about that. You'll notice in Plus, they have a field of publication date, so that you can generate, you can keep track of that as well when you publish photos. And so that if you register them after you publish them, you have that information. This is only as good as your update practices are, though, so you have to remember to keep all that up to date when you're engaging, or when you're taking images and using other licenses. So let me summarize. We've talked about a lot of this already. You register images as soon as they come off the camera. Can't overemphasize that enough. That means there's no question as to whether they're published or unpublished. Lina is probably a little bit of an understatement. It's unlikely they would end up in infringer's hands. And again, this is the other big one. It's provide as much information as practical on the application because it will strengthen the public record. So that's where I was talking about balancing. Like if you don't want to enter all the names in the field, that's fine, but understand that that's you're giving up some sort of value in that registration, potentially. But that's as a general rule, include as much as you can. All right, so that brings us to Facebook, which is the sharing and monitoring phase. We've done registration, we have the images, we're on a hard drive, now we need to do something with them. And this quote, this is from a listserv online, I forget which one, but I wanted to include this because it sums up so nicely the issue today. And it's so, I mean, it seems so obvious and yet it's so poignant, I think, is that basically we need to be able to use the internet and put our images online to get exposure, and that's how commerce is happening, right, in the digital image space. But as soon as I put them out there, they're going to get ripped off. And it seems like those two are competing values. And the only surefire way to protect your stuff is to not have it out there in the first place, which is just not possible in the current environment. And I always capture these examples when I see them. This was a wedding photographer whose stuff had been ripped off, and then caught the guy who ripped off his stuff wandering around a bridal show, showing off those images as his own to get clients. And there's a whole bunch of fraud and consumer protection stuff going on there, but you can see how enraged this photographer was, justifiably so. Apparently the second time. And then this was actually from one of my Facebook friends who posted this image, and somebody asked him if he took it, and he said, "Nah, I just swiped it off the internet." So it underscores how people don't understand copyright in a way that they need to. It's a real problem. I think our industry, not photography generally, but copyright owners have done a very bad job of educating people about it. So this has become a social norm. And that's the tide we're fighting against. And there are some organizations that are trying to right that ship, but it's definitely an uphill battle. Yeah.
How much is worth losing sleep? It's annoying.
Yeah.
But if they're not making money on it,
That's, yes. So that's
you're cease and desist, I think, right? It's just,
yeah. So I would, if this were my image, whatever. This is fine.
Yeah,
And
exactly.
well, in a minute, I'm going to get into things you can do to try to minimize this kind of stuff. And when somebody mentioned watermarks earlier in the context of publication, and if this were a watermark image, you would at least get some promotional value out of it, even though, as you say, you're not losing sleep because you're not making any money on it in the first place. But now you're getting a little more promotional value from it. And then the response usually is, oh, but you can just clone out the watermark, or I can crop it out, or whatever. Yeah, true, but we've made it, it's one of my principles of sharing, we've made it a little bit hard to steal. And we've elevated the bar a little bit and made it more difficult. Does it mean that people aren't going to do it? No, but it makes it at least gives you some value, and it makes it a little bit more difficult. People might just think twice. So, yeah.
How about if you take it, you register it out of the camera, then you take that image and put it in Photoshop and Lightroom and Mixed, and it comes out completely, well, basically different from what you registered.
So you're suggesting like an infringer might do that, and then claim that it's
Or
their own work?
yourself, does your registration still apply to that?
Yeah, right, so what you've done is created a derivative. And remember earlier I said creating a derivative work is the exclusive right of the copyright owner. You're just described a derivative. And then the next question that usually flows from that is, well, can I register that separately? The answer is maybe. If you've done enough to it, you've created a new copyrightable work, the derivative. You're probably protected by your original registration because, again, it's derivative of that. But the difference between the original work and the new work, if that contains copyrightable work, copyrightable authorship, you can register that separately. So I skipped it for this talk because it's in the weeds a little bit. In the book, I go into more detail about sort of what that means. Unfortunately, it's as usual. It depends kind of, so it's a case-by-case thing. So these are the steps for this sharing and monitoring phase. And by these first two, establish goals and select venues, what I'm talking about is something that came up earlier about Instagram, which is what are you doing with these images, and what are you trying to get out of it? Because it could be that if it's an Instagram, like I post stuff to Instagram all the time, I do not care about it at all. Like from a rights management perspective, people can steal it, people can do what they want with it. I'm not going to lose sleep over it. But then there's other stuff where I spend 3 weeks doing post-production work on something and put it out. I care a lot more about those. And so the point really here is just the way I treat the Instagram stuff is very different than the way I treat the stuff that I really care about. And this is, my message really here is you need to think that through for yourself and figure out what makes sense for you. The photographer I mentioned earlier, whose entire business model is based on Instagram, probably has a very different view of Instagram than I do. But that's because I don't use it the way she does. So you need to think through that, and that will give you a sense of the sorts of things you need to do when you're sharing your images. So these are my 3 principles that I mentioned earlier. We make it a little bit, make it really easy to engage with your work, and that could be different things for different people. So by engage, I mean, you want to let people look at it, you want people to license it, do you care if they're downloading things and using it as wallpaper on their phones? You might not. But the key is you need to make that easy because people, I've seen a lot of websites where it's not clear what I'm allowed to do and what I'm not allowed to do, and you just need to clarify that for people. And I found that for the most, there will always be the pirates, the people that want to steal your stuff. But for the most part, people try to do the right thing. If you make it easy, if you don't mind people using it as wallpaper, make it easy for them to get it as wallpaper. And again, put your graphics, put your logo on it, put your watermark on it, get a little promotional value out of it if you can. The next one actually has slides from here. That was my picture for the make it easy to engage. A little bit difficult to steal. So there's a variety of ways we can deal with this. We've talked about a lot of them already. We can add watermarks, visible watermarks. We can add invisible watermarks, or what's also called fingerprinting. Those are services like PicScout that go out and they basically catalog your images and then they find infringements for you. One of our sponsors today, Image Rights, I think in the back there's some flyers about them. They do that as well. They think they search every couple of months. They do a big internet roundup and see where your image is being used and then give you a list, and then you decide which ones are potentially infringing and which ones aren't. And they'll go a step further. They'll actually handle some of the enforcement for you in certain cases. So we can do that. We can add borders to our images. I'll show you just an example of what I'm talking about with that. Some services will let you disable the right-click feature on computers. It's really easy to defeat it. The easiest way is to just take a screenshot. But again, we're not trying to make any of this foolproof. We're just trying to make it so that it's a little bit harder for people to do it. I've certainly had situations where I wanted to use something as an example, fair use, and tried to use the right-click and it's been disabled, and I've just moved on, right? Because I can't do that. And I think a lot of people wanting to rip off images are kind of in that same category. So that's another thing we can do. Again, not 100%, but it's helpful. And then limiting the image size and resolution. This came up earlier. The idea of taking a picture of the work that you want to show or using a very highly compressed or cropped version makes it difficult. Like I couldn't take your images off of Instagram and do, more than likely, I couldn't take them and make, billboards or bus bench ads or things like that. So, or most print uses still require very high resolution. So by limiting what we put out on the internet in the first place, we can make it easier to control that. One downside to all these high DPI displays like Retina that Apple's using is that now, like if you look at websites that are optimized for Retina displays, on a Retina display, they look really terrible. And the problem then is we have to create websites that use higher resolution images. So it's getting harder and harder to do that as sort of an image protection tool. Because if you want our stuff to look good, it has to be high resolution. Excuse me. This is just an example of watermarking, just to show you that Lightroom now makes this really, really easy. This is within the export module in Lightroom, and you can put on the copyright notice right there. You can move it around. You can change the opacity. This is just a text watermark, but you can also apply graphics. So you can put your logo in there, again, change the opacity and things like that.
All rights reserved, is that highly recommended to include?
So yeah, there's actually a debate there's a very esoteric debate among copyright professors about this a while back. There's a really narrow treaty to which we are a member for which this is useful. It is not the end of the world if you leave it off, but it is such a standard way of phrasing it that I think everybody can still learn. It also, it also makes it very, very clear that you are reserving all the rights. So it's not, you're not giving them, it's actually kind of a misnomer. Like if I upload this to Facebook, I guess I'm reserving all of the rights I haven't given to Facebook in the course of the term reserved, but it's not taking into account the license that I've granted to people already. So it's almost it's not like I'm reserving all of the rights. I'm giving, I've licensed some of them, but then you wouldn't put that all in the field. So it is largely a historical anachronism, but it's still a commonly followed practice, whether it's a best practice or not.
I've seen a number of situations where there's no year put.
Yes.
That's okay?
Yeah, well, it's kind of, technically it is not a notice as provided for by the Copyright Act. The Copyright Act requires it be the date of first publication or the year of publication, but nothing happens if you don't have a notice. The only potential thing that happens is that a would-be infringer could argue that it was inadvertent infringement. I didn't know it was protected by copyright. If I have this on there, I can't argue that. It would be unlikely to me, it seems unlikely to me that an infringer would say your notice was invalid because it didn't include the year. Or more accurately, I could see them making that argument. I don't think a court would care when they're doing it. But the technical form of notice is provided by, I think it's Chapter 4 of the Copyright Act, says you include the year of publication. So, I do. But again, it's kind of up to you what you want to do. A lot of big corporate users just write C and they don't include any of the other stuff, which is also part of their formal. The name of the copyright owner is also part of the official form for the copyright notice. But since you don't need to have notice to have a copyright, excuse me. There's another example of watermarking. This is within Photoshop. And so you can, what I like about this is that I can upload full resolution. I trust Photoshop for security. So I upload full resolution images, and they can make them available to people who pay a license fee or who want to buy prints. But then they'll put watermarks on them when they're displaying the thumbnails. And so they do all that for me. I don't have to mess around with uploading watermark versions and then the full res versions to make the prints from. They just handle it. And it's something that looks like this. Again, this is Photoshop. SmugMug, I think, does the same thing. Zenfolio, I suspect, does the same thing. All the big commercial providers will probably have something very similar. I mentioned image borders earlier. This is an example of that. This is sort of your point earlier about getting some, do I really lose sleep? If this image got out, I don't really care, and I kind of like the fact I'm getting some promotional value out of it. I'm probably being a little foolish here because I should have a web address there because this is just, it's not the most unique thing in the world. So it's probably pretty easy with Google to find me, but it would be easier, it would make more sense if I had a web address or some way of actually identifying. But the border just, again, you could crop this out, right? I really personally do not like watermarks. This is one of those things where it's like religion. People swear by watermarks and they think they're terrible. I just don't like ruining the image with them. I totally get why some people want to do that. So I've settled for this, which is to put a border around it, give me a little bit of branding. And again, somebody would have to crop this out to rip off the image. They're going to do that. Some people will do that. I'm not going to lose sleep over it, but this makes it a little bit better. You just ask, yeah.
So the border is all the black included, that's something you set up before you export it?
Yeah, I do that in, I'm doing these in Lightroom as well with a plugin. I think the plugin is donationware, so it's like, you pay whatever you want for it, so I think I gave you $20 or something like that. But it's useful to do this, and it's also the tool I use to add the borders for the deposits for published registrations. So I showed you there. So it's the same tool. And then we already talked about this. PicScout and Digimark are a couple of companies that do image recognition tools, and fingerprinting, and watermarking. PicScout's more commercial. I think they cater mostly to agencies, whereas Digimark, they have products for individual photographers and things like that. So it's something to look for. Digimark, the standard Digimark ID embedded has been in Photoshop since like version 4 or something, so it goes back a while. They've updated it since then, and they've got a lot more tools on the back end. And then the third step is this idea of being reasonable, or as I often refer to it, just don't be a jerk. And I think I mentioned earlier, there's a lot of photographers on the web, who I imagine look like that post these really nasty notices about how terrible you are, this other stuff. And yeah, I get it, but it's just, I've actually left websites where I have to click through so many things to get too many images that I just don't, just didn't care anymore. And so this is just sort of a reminder that we need to be diligent in protecting our stuff, but not so much that people hate us, because then this is what the music industry did. They sued everybody, and they sued users, and now everybody hates the music industry. People hated the music industry before, but now they see them as this, horrible group of people that are just, they'll stop at nothing to enforce their rights. And they have a right to sue those people, like they were, in most cases, they were people that were stealing the music. But the way they went about it really engendered this horrible impression of the copyright industry that we're now trying to claw back. The tide is turning against copyright, unfortunately. And so we're trying, and the rights industry is trying to claw that back. And so by being very reasonable and helping to educate people on why they would want to respect your work, I think we could start to change that a little bit. So, what time are we? So in terms of use, we've already talked about a little bit. Somebody mentioned earlier Instagram and how they can now use your work commercially if you upload it. That's true, and I think I followed up with, have they actually done it? And I think the answer is no. My view, and again, this is something else I don't lose sleep over, a lot of times these terms of use are written to be so broad because they're written by a lawyer whose sole job is to prevent the client from getting sued. And if you throw everything in the contract, and so if you're giving all the rights for everything, the likelihood of them getting sued is low. That's why I did that. Yes?
I have a different view. When Instagram, or I should say when Facebook went public, that's when you started to see a lot of this in the terms agreement. And I believe, because I believe in the sinister nature of Mark Zuckerberg, that he's looking down the road to building values for the shareholders.
Yep. No, absolutely.
So that's the.
No, and
I think it's intentional.
Yeah, no, that's totally fair. And I think that on some level, that's exactly what they plan to do. I don't think they're going to, I just don't believe they're going to unwittingly take people's images and start selling them as stock. I mean, the way those licenses are written is they could basically set up a stock agency with everything that they're uploading, right? And that's outrageous. And that's another reason why we would upload, like, they don't, it gets a little tricky, but they have the right to license the image that you've provided to them, but they usually can't, because the visual rights can't manipulate that image at all. So if you upload it with a bunch of watermarks and stuff, they can only license it with a bunch of watermarks and stuff. So it's another reason why, at least that's my impression, and this hasn't been tested yet, so who knows. Facebook is famous for pushing the boundaries, so maybe they'll try this.
How can one find out limits, like for specifically LinkedIn, you want to put an image there, how would you know on that what those, what
What's that? Sorry, you just, what did you say? You added something?
Oh, so it's like, for example, with LinkedIn, if I want to
Yeah.
promote on there, how would I know what the agreements are without reading the pages and pages?
You can't, I mean, that's how you do it.
That's the only way to find out.
There are ASMP, I think it was ASMP. Correct me if I'm wrong, something that.
We did.
APA.
No, APA did. So somebody put out like so APA put out a document that sort of highlighted, I think, key terms, and I think came to some conclusions about like this one's safe. this
Yeah, and
one's-
we have a lawyer who checks it every
Okay,
quarter.
yeah.
And we update, so,
Okay.
but even on our side, it's long, you have to really read it. But we delineate each terms of use and what it means and why you need to be careful.
So
Oh,
APA is a good resource for that.
Yeah,
And they,
APAnational.org. Little plug.
and again, it's all about risk management, right? So like I don't post, what I usually do for Facebook is I'll post a link to my blog. So that way they don't have all they're actually posting on their site is a thumbnail from the blog as opposed to the full image. So that's, again, I'm not aware of any suits about that and how that shakes out and whether they claim a right in the full image. It's entirely possible they try to do that. But from my perspective right now, that's probably the safest way to do this. But the bottom line is like the kind of stuff that I'm posting on Facebook, I don't worry that much about because it's not, that stuff is not what I'm making money from. So again, this goes back to that first point I made about how you really have to think through what you're doing, what your goals are, and how much effort you want to put into protecting it based on those goals. One thing I did want to mention in terms of services, every so often, and it's amazing how quickly these things spread, is you'll see people posting stuff like this about how they don't consent to the new terms of service or whatever. It's complete BS. It has absolutely no relevance or value whatsoever. The bottom line is they do change their terms all the time. You're agreeing to those terms by continuing to use the site, and it's always very clear that that's what you're doing. This one I particularly enjoy because it references the Burner Convention, which is not a thing. It's the Burner Convention.
What year was that? What year was the Burner?
It's dated now, 18 something. But it's these just don't do this, don't buy into this because it has absolutely no value whatsoever. I just wanted to be aware of that. How many of you have heard of Creative Commons? Have any of you released anything under Creative Commons licenses? So basically, Creative Commons is a standard licensing scheme that encourages people to make their use available for free on certain fairly broad terms. And there's a strong perception in a lot of the pro-copyright industries that that's a terrible thing because it weakens copyright and encourages people to share stuff. And I kind of have two views. On the one hand, it's accelerating this, it's socializing this social norm that stuff should be free. On the other hand, it's actually very empowering for copyright owners because the Creative Commons licenses are just that, they're licenses. So you're granting permission under the terms of these licenses to do certain things with your work. And so I've actually done, I was teaching for a while a law school course on copyright policy. I released a lot of that stuff under Creative Commons license to allow other professors to use it without any concern that they get sued. But for things that's because I made the money from that from the teaching, not from the materials themselves. Photography, I can't see a reason why a professional photographer would, in the ordinary course, release stuff under Creative Commons license. But having said that, some have. So Trey Ratcliffe, if any of you are familiar with him, he's an HDR aficionado. He's very prolific. I'm pretty sure all of his stuff is under Creative Commons license for non-commercial use. If you want to use it professionally or in any kind of commercial context, you have to license it through the traditional channels. But the way he makes all his money is on selling educational tools about how to do HDR. So for his business model, it probably makes a lot of sense because he's creating buzz around his name, buzz around his work, and he doesn't make money on it, or that's not the primary source of his money. Right? So again, my view is it's a little less draconian, I think, than some of the trade associations that say Creative Commons is terrible. There's a very prominent lawyer that runs around just destroying Creative Commons, and it's silly because it's becoming a very commonly seen tool that's used by rights owners who don't understand licensing and want to rely on it, and that's fine. Yeah.
Was it Lawrence Lessing that created?
Yeah. He was.
What part of probably the dark side of that, or people's perception of it, and I was surprised it's not that dark.
Mm-hmm.
Was he was the guy that wanted to abolish copyright, and now he's backing away from that. He's walking that back.
Yep.
So Creative Commons is not abolishing copyright, is not, which was his original edict. Right?
Creative Commons wouldn't exist without
Right.
copyright law. It's a
So it's
license,
interesting, because he's
so-
backing away from his original stance, was that there should be
Well,
no copyright.
I would take, I don't think he ever really wanted to abolish copyright. He wanted to reconfigure it in a way that was very inconsistent with what we're familiar with.
Well, I think he wanted to make a name for himself more than
Well, he was a professor that was publishing a lot of books, and some of those books are very good, and others are not so good. He's become very more on political, non-copyright issues, which is fine. One thing to keep in mind, though, with Creative Commons is that it's becoming so familiar that even on sites that ostensibly cater to professionals or semi-professionals are starting to use it more and more. They have to be really careful about this, because what happens is, for a while, I don't know if it was 500px or if it was one of the other sites, but they were defaulting new uploads to Creative Commons licenses. And the result of that was people were then downloading those images and legitimately thinking they could use them because according to the site, it was a Creative Commons license, but it was never intended by the photographer. And Creative Commons takes the view that those licenses are irrevocable, and once you've released something under that license, you can't revoke it again. There's a reason why I don't think that's legally correct under copyright law, but that's the position, and that's kind of the public messaging around this. So you have to be really, really careful about it. The other place this comes up is if I rip off one of your images, I could then upload it to one of these sites as a Creative Commons licensed work, and to a downstream user, they have no idea, right? And so now you're bringing a suit against this guy who thought that he could use it because it was on 500px under Creative Commons license, and had no idea that it was actually from some other person. And that actually happened to Trey Ratcliffe. One of his images ended up winning a contest held by a local newspaper in Australia that he never entered. And it was because somebody had pulled the image from a Creative Commons licensed source, thinking that it was a legitimate image, and it in fact was not. So there was, they sort of disappeared from the press, so I suspect Trey and his staff came to an agreement with the newspaper over that. This is the metadata thing I was telling you about earlier. This is another thing I wanted you to be aware of. We've already touched on it. A lot of these sites strip out the metadata. You can see, as of the time of the screenshot, Facebook was particularly egregious. But they have, this is sort of the dashboard. They have a more robust report that sort of goes through what some of the major services do with your photo metadata. You can see Dropbox, as I would expect, because it's a source. It's pretty good with metadata. Flickr, not so much. Facebook, not so much. It's interesting that that's a free account. This is also sort of dated. It's January 2013. I'd be interested to know if Flickr's paid products offer more robust metadata than their free. But anyway, it's frustrating because, like we were joking earlier, they asserted the stated reason for that is space, but it's a couple of K at the most, right? I'm not a data expert, but I can't imagine compared to English that that's a lot of you're saving a lot. Sorry, I did the wrong button. Cancel the show. Okay, so home stretch. This is sort of what I was talking about, thinking about your own impression or own goals and objectives. This is sort of what I've come up with for my own personal work. Is that I have images on which I've done extensive post images that are sort of halfway there, and then just shots I take with my phone. And I won't go through all these, but you can see how these are sort of my rules for loosely for what I post where and under what conditions. And I should note that I actually often do not follow my own rules. So this is just sort of what I this if I were a corporate art department or something thinking through how I want to manage my assets, I would come up with something like this. I do sometimes follow that stuff, but if you're making money from your images, you want to think through at least, and you don't necessarily need to do it at this level of detail, but something you should think about. Monitoring tools. So we talked a little bit about reverse image searching. It's a very manual process, but like these are a couple of images that I uploaded to these services. This is just Google image search on the left and TinEye on the right, which is TinEye is free for non-commercial use, and then you're supposed to pay for it for commercial use, but I don't think they have any way of verifying that. I'm not really sure what their end game is. I thought they've been around a while, and I assumed they were trying to license the technology, but I haven't seen it used anywhere else, so I'm not sure what's going on the back end. But long story short, they scour the web and show you all the places where your image is used. And you can see here, these are all my sites, so I'm not too worried about it. And then further down, there are some agencies that list that. Very manual process, though. You have to upload the image and kind of scour the result yourself. I mentioned earlier image rights, which I was going to talk about anyway before I found out they were sponsored, but they offer this sort of automated process where you upload your images and then they'll email you when there's hits, and then you tell it whether they're infringements or not. The other thing they've started doing is a copyright registration service, and I believe if you pick up the flyer in the back, they will give you a registration for free. So you definitely want to check that out because they will cover the filing fee in addition to their own fee. I think they're charging about $100 for registration, which is more than what the Copyright Office charges, but obviously the filing fee is included. Useful if you don't want to do your own registrations, but the whole goal of this is to show you how to do some of that. So up to you whether you use that, but I would definitely take advantage of the free one. It's free for covering your filing fee at least. One thing I wanted to point out, be really careful when you're enforcing or looking for infringements that you take into account who you granted licenses to. And a good example, if anyone who's doing royalty-free stuff needs to be really careful about this because it gets out there and then you have no idea whether those uses are licensed or not. Like I have a bunch of stuff on my side, and you punch in those images and there's like thousands of hits for it because they've been licensed thousands of times. I don't get information from my stock getting to figure out who's actually licensed it and who hasn't. So I can't go and send cease and desist letters to all these websites because it's true that I have not licensed them, but I have no idea who iStock's granted a license to. So for that kind of stuff, it's really difficult to figure out whether a use is legal or not. My argument is the value per use is so low because that's the whole model of iStock royalty free that for me, it's just not worth enforcing on. I think down the road, we're going to get to a place where that can all be automated, so their system can figure out what a licensed image is, and then it will spit out a list of infringing sites. And I suspect that is why Getty bought PixScout a few years ago. I would imagine on the back end, that's exactly what they're doing. They're like high-value images. They're probably running lists of where that image is found and meshing that with their licensing database and figuring out which ones to enforce. Getty's been very active in enforcement, but they have the tools to do it. So as individual photographers, you just need to be careful not to be sending nasty letters to people who lawfully licensed. It kind of goes back to the don't be reasonable, don't be a jerk slide I mentioned earlier. So very quickly, let's assume your work's been ripped off. What are your options for doing something about it? You can ask them very nicely to stop. Sometimes it works, sometimes it's a surprise, often it doesn't. You can issue a takedown notice under the Digital Millennium Copyright Act. That's a very specific procedure. I don't want to get into the details now. There's been a lot written about it. But it's basically a law that gives internet service providers a pass if they're facilitating copyright infringement, provided they agree to take down infringements when they're notified about them. And there's a very specific set of rules you have to follow to issue those notices. They're not complicated. It's just you have to put certain words in the right place, basically, to get that done. You can send a cease and desist letter. That's kind of like a takedown notice, only it's not prescribed by any sort of guidelines or standards, and it's a little more. You can kind of say what you want in those. There's a propensity, particularly among photographers, to send really nasty cease and desist letters. I suggest you do the opposite and be a little more polite. And a company I used to work for, we would always put in our cease and desist letters that we fully understand that the infringement was probably inadvertent and we know you didn't do any harm, but we really appreciate it if you stopped. And we knew full well that most of these were just thieves, they're stealing your stuff. But doing that, you're creating a record, you're the reasonable person, and then if you do end up in litigation and the court sees all that, you will look like you did everything you should have done, and you weren't being reasonable, which is helpful. And then speaking of being a jerk about things, the last thing is litigation, which is going to court, suing somebody. That is extremely expensive, and it really only makes sense if you have high dollar values at stake. So that summarizes them. Again, I'm not going to walk all the way through it, but asking nicely, really cheap, but also not super effective. Litigation, really expensive. It takes a long time, but it could be very successful if you wait. So, yeah.
What about between cease and desist and litigation? What about sending a letter and saying, I expect payment from you?
Yeah, so I would include that in the C and D category. That's one option. One place people get into trouble, though, is they'll reference an amount in there. So a lot of photographers will do this, we're going to sue you, or we want 5 times the license fee, or something like that. That's fine, but understand you've now created a value proposition for what that work is worth, which, depending on whether the court considers that settlement negotiation, if it isn't, it would be admissible in court. And you may not want that because you may have undershot it. So you want to talk to a lawyer. If you're going to do that, you'd want to talk to a lawyer first to make sure that you're estimate or appraiser really, to make sure that you're getting the value proposition correct. Because otherwise you may be stuck with the numbers, which could be wrong. So you just want to be very careful with that. It also leads to people making extreme demands. You get cease and desist letters all the time for people. It's an image you could have licensed on iStock for a few dollars. So just that often you get sort of both ends of the spectrum. You just want to be very careful about creating a record. Remember that if you're heading towards litigation, everything you do here is creating a record that can show up in litigation. So you want to think about it in terms of what the court's going to think, what the judge is going to think, if it gets there, what a jury might think, if they see that. All right, so that's the enforcement piece in a nutshell, a really big nutshell. I want to talk very quickly about the future. So I mentioned this a few times. A common theme today has been that the Copyright Office system does not work very well for photographers, and that, frankly, many aspects of copyright law do not make a whole lot of sense for photographers, particularly in the enforcement space. On Wednesday, the director of the Copyright Office, Maria Palante, will testify before the House Judiciary Committee, basically summarizing 2 years of hearings that the Judiciary Committee has held on copyright-related issues, a number of which touch on photographers' concerns. So the point of all this is they're thinking about things, and it's on everyone's mind. There's very likely going to be some legislation in the next 3 to 5 years on copyright issues. And they very likely will relate to getting the Copyright Office some more money and potentially out of the Library of Congress, which will help dramatically in improving some of those things. And then another issue they wanted to tackle is giving the Copyright Office more authority. And one of the things that comes up a lot is giving them the right to create a small claims court that would allow photographers, for example, to sue in this sort of limited tribunal, so that you wouldn't have the expense of full litigation. It would be done. The proposal from the Copyright Office is it would be done telephonically, only on the papers. You wouldn't have hearings. And things like that, that would reduce the cost and the burden on the photographer and would allow you to access enforcement tools that are otherwise too expensive through the court system. So these are all, that's a long way off, but I just wanted you to all, there's been some doom and gloom in earlier parts of the presentation, and I just wanted to say it shouldn't all be negative. These issues are very much on the minds of policymakers. And actually, just as recently as yesterday, the Copyright Office issued a public inquiry, notice of inquiry, asking specifically for photographers' views on issues facing photographers right now. So if you're interested in that, go to copyright.gov. I can't remember the detail at the moment, and you can find the notice there, and I urge you all to respond to it. I forget, do either?
And it's on APA National.
That's probably easier.
Advocacy section, it's right there.
There you go. So all the big trade associations will file, APA, PPA, ASPP, Copyright Alliance, I'm sure. But I actually would encourage individual photographers to share their own experiences because those are very compelling. So don't rant, but having some views from actual people who do the work can be very, very useful if the Copyright Office, because what will come out of that is a report that the Copyright Office will then use to go to Congress and say, look, there's a problem here, we need to do something about it.
And Maria's on our side. Maria's a good
Yeah,
good
so
guy.
that's an excellent point. Maria Palante, the current director of the Copyright Office, has a strong, she used to work for the Guggenheim, and she has a background in the museum. So she is very much in tune with the issues that are facing visual artists and really does want to do something about it. So we have the right people on our side. It's just a matter of getting Congress's attention on those specific issues. And of course, it's copyright. So you look at our issues are very narrow within copyright, and copyright is really not the most important thing on Congress's plate either. So it's hard to get traction, but the momentum is building. So it shouldn't all be doom and gloom. So don't leave today thinking it's the end of the world. It isn't. So that's kind of it. That's the workflow again. I just wanted to point out, I guess, one other thing. I've set it up as a workflow, but really it's a cycle. The planning and setup you kind of do once, but then somebody mentioned, like, what if you move? You want to be constantly mindful of the things you might need to update. So you need to update your presets periodically, make sure the date and time of your camera is correct when the daylight savings time hits every year. Update the copyright notices if you're publishing, the new year hits and you're starting to publish things, update the date of the copyright notice, things like that. But it's really a continuous cycle that I wanted to sort of summarize. I presented in terms of like a linear workflow, but it is more of a cycle that requires constant updating. And then finally, and I waited till the end, the shameless plug. This is the book I wrote came out last year. If anyone, the economics of book publishing are such that it didn't make sense to have copies here to buy. I have a couple you can look at, but I don't have any to sell. If you would like to buy it, I have links to all the major booksellers at copyrightworkflow.com. And if you order from Peach Fit Press directly and use that coupon code, you can get 35% off with free shipping. So I'll just be very honest with you, even the 35% off price, I think it's right around, gets you to right around what Amazon's selling it for anyway. So if you're a Prime member, you'll probably get free shipping. You're probably better off just ordering from Amazon. But I don't really care where you buy it. But if you're interested in it, there it is for you. And I should mention too, there's lots of other resources. It's not just this book. The ASPP has a really great book out on these issues. They have a good web tutorial, totally free, on how to register your work, which is still very good. John Harrington's book I mentioned earlier has a lot of techniques in it. Nancy Wolf, a lawyer out of New York, has a very good book. Less nuts and bolts and more policy stuff, but still very, very interesting. So there's lots of sources. I'm happy, if anyone, you can contact me through that site too. I'm happy to help guide you to the right place if you have any questions. And I'll end it there. If you have any questions for me now, I'm happy to take them. Thank you all.
This may open up another kettle of fish, and so it might be something that you could at least point us in the right direction. A lot of us here are, I mean, we may take pictures, but we're not primarily photographers. I'm a photo editor, doing photo research, and I often have sort of the opposite problem, is that I'll find an image and, you know, don't want to steal it, don't want to violate anything, but maybe the image has been published so many times, or has, if it's made it onto Pinterest or to Tumblr, you can't find the original source of it just by doing like an image search from Google. And but you want to be able to find out, is this image copyrighted? Can I call someone? Can I get, you know, because either permission or can I license it? What can we do?
Yeah. So you took my one suggestion, which was try to reverse image search. That's the challenge, right, for photographers. Is the Copyright Office database, which is supposed to be the authoritative source of copyright ownership information, doesn't include images, so it can't help you there. The PLUS Coalition that I mentioned earlier is creating a database that would hopefully do that, so it would allow you to link the Copyright Office data to their database, which would contain the images. But the short answer is no, I don't really have any great suggestions on how to do that. That's the problem, is we're in this, you know, culture, rich visual culture, and there's just so much content that figuring out who owns it and losing sight of it, you know, and that gets lost. It's very hard to find.
Yeah, APA's recommendations don't use it. If you cannot definitively prove that it's either in public domain or that it is an orphan work, do not use it, because the cost, you know that, I'm sure you know that, and I'm sure you don't, but that's what we're recommending, but there is no definitive way of finding things now, which is the problem.
Yeah, it's very frustrating.
I know,
I mean,
I know.
you do due diligence and, you know, you make notes about what that is, and then you say the risk is, I'll go forward, and should the owner contact me, I'm glad, I was looking for you, thank you for contacting me.
But if you've already used it, then you've infringed.
And a lot of times
Yeah,
you're doing
if you've
things,
done
you know,
due
by the
diligence,
time someone can
fine.
find you, if you're doing things on a deadline, I have, you know, 3 hours to make this decision, and
Well, let me run that for a second. So the due diligence point, the problem with copyright law now, the problem from the user side, is that copyright law is what we call strict liability. You copied it and you didn't have permission, you want it. It doesn't matter that you tried your best to find the owner or that you worked really hard. It doesn't matter. Now, the court might consider that in the course of figuring out what the damages should be if there is a litigation, but as a matter of technical liability, it's irrelevant that you did your due diligence. A number of years ago, there was a proposal to introduce, or there was an introduction of what's called orphan works legislation, which is the situation, an orphan work is exactly the situation you described. It's a work where I have a picture or whatever it is, and I can't identify or locate the owner. And that law basically would have capped the damages on circumstances, as you described, where I've done everything I can. And the everything I can is a pretty loaded term. There's a lot of stuff in the law that would set forth sort of best practices for searching for things based on the type of work. So, and those would be set by the Copyright Office in consultation with organizations like APA, ASPP. But the law would have, if you would follow those rules and done your best and documented it, as you just described, you would be able to use the work without fear of being sued for the full statutory damages amount. It capped it to, I think, a reasonable license fee. And when this was first introduced, photographers went crazy. And they were actually, some people in Washington would assert that the photographers are the reason the bill never made it. It's probably a slight exaggeration. It's certainly part of the problem. And it's understandable because photographers' works are the ones that are more likely to become orphaned. And so there was this concern that you'd have this database of orphaned works somewhere that anybody could use, because then there was now documents like, oh, we can't find this guy, so use this one. And it would be like a stock library of orphaned works. The catch was that actually never would have happened because the law required that each user perform a search that's reasonable under their circumstances. So the type of search that I would be required to use to engage in as an individual for a PowerPoint presentation would be very different than the search that Disney would be required to engage in if they were using it in a commercial. So it was, you had to redo the search each time, basically. But the punchline is it made it through the Senate, it didn't make it through the House, and it's never been reintroduced. There's a strong likelihood on Wednesday at the testimony I was describing that Maria Palante is going to renew her call for something to be done in orphan works, because it's a huge issue for where her heart lies in the museum and in that community, certainly not properly law. Because museums have treasure troves of works, but they don't know what they can do with them because they don't know what the copyright status is. It's the same issue you have. So the point of the protracted story is, I totally agree. If there's any question or potential liability, don't use it. But relief's on, maybe on there for kids. But remember my time horizons through years. Yeah.
A lot was discussed about photo sharing sites. Does that also encompass your business website? In other words, is it much risk of having my images stolen from my website?
Yeah, I mean, so I tend to put less security on images on my website because it's my billboard and I don't want it to look cluttered with stuff. But are you asking if they can be just as easily ripped off from your site?
Yeah, and should I still mark each image, or can you do something at the head by entering this site, you're acknowledging that all
It all helps a little bit. The only thing that makes me nervous about the by entering the site stuff is you get into that territory of looking kind of like a jerk about it. Right. So you got, I mean, if you phrase it right, I think that's fine. It's a balance, right? Because you don't want to come off as being really standoffish, but at the same time, you protect yourself.
But anything, once it's on the digital screen, it doesn't have it's on Facebook or your website, it's all easily.
Yeah. I mean, what's tricky about it is that the way the internet works is making copies. Like if I pull up a website right now, it's pulling everything from, if we have a copyright on this website, it's pinging Washington, it's downloading all those assets from the website, the graphics, the headers, all that, and displaying them on my computer. So they're in my cache. So the rule can't be you can't make copies of those because the internet will break. So you have this sort of dynamic of like, how do we deal with that in the internet community in a way that protects the legitimate rights of the rights owner, but also allows the internet to work. Because nobody in this room wants the internet to break. Right? And I'm using that as a purposely hyperbolic example, but that's kind of the issue, is that the new technologies have to do a lot of things that traditionally only copyright owners can do. And we're in this new world where we need to be able to do these things, but in a more mechanized or automated fashion, just to get the technology to work. And so we need to you hear this a lot in copyright conversations about restriking the balance. You hear it so much it's become kind of trite, but that's really what it is. It's trying to figure out where that line is between what the rights of the copyright, I was talking about limitations and exceptions earlier, like what are the reasonable limitations and exceptions relative to digital technology that would allow the next Facebook to be Facebook? Because the arguments we always hear, when we want to tighten the screws a little bit on illegal search, illegal image sharing or something, is the argument from the tech sector always is, well, if you put too much regulation on us, nobody will give capital, and we'll put capital into that market, and then we won't get the next Facebook, the next Instagram, the next whatever. And there's a balance there. Like that's probably true if you go crazy and lock it down too much and just riddle it with liability, nobody's going to go there. But if you don't give them any liability, there's no reason for them to comply with anything. So it really is balancing those two interests. That answer was a far cry.
No.
Hopefully,